There was
one judgment.
one observation we had made in where Mr. Kinjing had appeared in those criminal appeal. There are 3. So Chief Justice has cautioned the appellant whether you risk, going with a single appeal or you want to take it separately. It's up to you. Because once it is a single appeal means it binds everyone.
Madam, it is here, Miller.
It would be common judgment, no doubt.
Madam,
what is the case about? Section?
Miller, it's a life imprisonment on 302.
302. It's up to you.
But I think it's all right.
No
objection. 48 days.
Heard Mr. S. Chakraborty, led senior counsel appearing for the applicant, who has submitted that the related appeal filed by the appellants against a common judgment and order dated.
The sentence is on 7th of September.
What's the date of the
judgment dated 4/8/2023?
4/8/2023.
And the sentence dated 7/8.
And sentence dated? Not necessarily. Has been preferred for this court with an application for condonation of delay of 48 days. Condonation for filing the appeal is therefore sought for on hearing the Land Council and the landed PP appearing for the state respondent, who has no objection to the prayer made. The court, on observing that there are good grounds for filing of the appeal, the delay of 48 days is hereby condoned. MC, this case is hereby disposed of. Registry to diarize the appeal and give a number accordingly. The appeal be admitted. The court records are hereby called for. The appellant is hereby directed to prepare the paper book within 6 weeks. Within 6 weeks.
Obligement.
Thank you.
Obligement. Grateful to your Lordship.
Item number 2.
Again, raise one of the 5 countries.
May it please Lordship. Your Lordship, this is an application for condonation of delay of period of 543 days.
Excuse me.
Your Lordship, this appeal was previously filed jointly. However, the same was withdrawn, Your Lordship. White order dated 22. White order dated this one 4/7/2023, Your Lordship.
So after it was withdrawn, the delay was caused.
Yes, Your Lordship. No, Your Lordship. The delay was. We count the delay from the first appeal, Your Lordship.
Is that how it is to be counted, Mr. Khan?
Technically, no, Lordship. But since it's a criminal appeal, actually, on matter of principle, I don't think so. Even if you object,
no, it's not a question. It's a question of, like you rightly said, the technical part of it.
But knowing this, when it comes to criminal appeal, we don't want to necessarily delay in filing a show cause and bring it. Leave it to the discretion of the court.
The applicant has filed this application seeking condonation of delay of how many days?
543 days, Your Lordship.
543 days in filing the related appeal, criminal appeal for this court. On good grounds being shown, the delay is condoned. The same not being objected to by the landed PP appearing for the state, for the opposite party. accordingly, this case also is hereby disposed of. I take it same order, huh? 6 weeks.
Item number 3, Your Lordship, this is a connected matter. Your Lordship, with this
So same order.
Same one, same one.
Item number 4, obliged, Your Lordship.
Hidden key order matter.
My lord.
You ready to continue the hearing?
My lord.
So we'll take it up after the main list is taken up.
From the main list, item number 1.
May it please, my lords. The leading county counsel, senior advocate K. Paul is not available in this moment, lordship. So I pray that this matter can come up on 8th December, lordship.
Why 8? We'll list it after 2 weeks.
But there are 2-3 issues, my lord. My lord, they have not annexed the relevant material from what was before the learned single judge, my lord. And secondly, my lord, the original pleadings before the learned single judge
You
is
have pointed out.
50 pages petition, 50 pages affidavit, my lord. Now the paper book here is of 500 pages, my lord.
They said that you will explain. We'll wait for that. So 2 weeks then. On prayer made by the appellant seeking accommodation on the ground that the learned conducting counsel is indisposed for the day. This matter is adjourned. This is after 2 weeks.
Deeply blessed.
Deeply.
Item number 2.
Made clear.
Just a moment.
Yes, my lord. In both the matters, my lord, we have filed spot affidavit in the morning only, my lord.
There,
281
as
may
far
not be-
as far as 281 is concerned, affidavit is only with regard to that minutes.
The minutes, my lord, yes.
Yes, notification and
Notification?
notification and that's all. A notification, there are 3 things which need to explain, Minutes is also placed on the record. That is the bylaw.
Mr. Majumdar?
My lord, I don't have a copy of the affidavit on me as of yet. I have got the minutes of the meeting. If I may just point out, there were 7 agendas taken up in that meeting. If lordship has a copy of the minutes, my lord. My lord,
But Mr. Advocate General has also pointed out that the notification has also been placed on record by way of the affidavit.
I am yet to receive copies, my lord.
Yes.
I am yet to receive.
So you
My
give
friend is having.
So you give him a copy then,
My lord,
Mr. Karan.
Lordship will be filing the cause of a day, Lordship, if Lordship permits.
So we'll take it up after 1 week then.
Yes, after 1 week.
If you want to respond to
My lord,
same,
1 week was also what I was, 1 or 2 weeks was what I was suggesting, because now they have circulated the papers which require to be signed by all the members so that the trust can be registered. It will take a week to register the trust and maybe apply for a PAN card and get another 1 week to get the PAN card. So that would solve out the problem. Officially the work should have been
All
done.
these will not be required. All these will not be required, my lord. The requirement is to act as per the statutory provision. We are acting
Exactly,
on-
that is what I was saying. They have circulated a piece of paper which says,
So therefore, there is nothing left for adjudication. Once the direction of the Honorable Supreme Court is there that we have to implement, we are implementing it. So every clerical step we are taking may not be brought. I will place it, Lordship.
that is, I think, Mr. Kumar, I think that is not what Mr. Majumdar is implying.
that is what I was.
No, what Mr. Majumdar is saying, Milan, to my understanding, is this that there are various steps which have been taken to implement the provisions of the Act. So first requirement was to issue notification modifying the earlier requirement. So we did that, and thereafter we are implementing it, Milan. Now at the stage of implementation, Milan, there are various steps which are required to be taken.
True.
So therefore, it is taking some time to
Yes,
do it, and parties are doing it. So whether
That
for
is what
that
I was saying.
purpose, Milan,
That's what he was saying.
Exactly what I was saying.
That's what he was saying.
So what to show your lordship is that if your lordship will see what is the issue which is in the petition, whether any issue is left for adjudication by your lordship or not. Let me place that affidavit, and then with the help of affidavit I will clarify the.
If you want some more time, then
Let it be
if
done.
you
No
if you-
difficulty, my
in
lord.
in the meantime, if you are required to take any steps, you
My
do
lord.
it.
Yes.
Then you come with a
Definitely, the government is helping us. The government is trying to come up with it.
Yes.
What I was suggesting is a week or two more would get things done. Will help the things get done. We are the consensus.
I believe as far as this matter is concerned, I think the government and the petitioners are on the
Yes, yes.
same page.
Simple. They are working hand in hand to have the.
So
Yes, my lord.
it augurs well for all concerned.
My lord, yes.
On premiere by the parties, let's this matter after 2 weeks.
The other matter, they were to file an affidavit in opposition. The
In both the matters,
That
what
you
should be
have
filing
you
in course of
received?
day.
You have received? Have you received copy of the?
no. Perhaps they'll give it to me today.
We
Filing
filing
is
in course of day.
If you want to file a rejoinder, 2 weeks.
2 weeks.
What's the other case number?
281 and 2360.
Based on their affidavit, state's affidavit, whether to reply or not, to add some point to the state's affidavit or not, I'll be also.
If you want to file your own affidavit, do it. Mr. Kumar has, the Advocate General has submitted that the affidavit, counter affidavit by the state respondent has been filed in this matter. Ms. P. Vachari, Learned Counsel for the respondent number 3, has also submitted that the respondent number 3 may be allowed to file a counter affidavit if so required. Mr. Majumdar, Learned Counsel for the petitioner, has however submitted that the copy of the said affidavit has not yet been received by the petitioners, and on being assured that copy of the same will be supplied to the petitioner in course of the day, the Learned Counsel has submitted that he may be allowed to file a rejoinder if so advised to the said counter affidavit if so advised. On premiere, this is matter after 2 weeks.
Obliged.
Item number 3.
My lord, here there are two writ petitioners were there, my lord, before the learned single judge. During the pendency of the matter, my lord, this pertains to a certain appointment in Nigrims, my lord. So what happened, my lord, during the pendency of the matter before the learned single judge, the petitioner number 2 got some other appointment in some other organization, my lord. So Mr. Bhattacharya at that point of time appeared for both the writ petitions, my lord. And he, as such, didn't pursue the matter because he already got now another appointment, my lord. Now, since they were petitioners, we have read both of them as respondents, my lord. Mr. Bhattacharya on last occasion also appeared only for respondent number 1, my lord, who was the petitioner number 1. So on number 2, we have taken steps, your lordship, by last order is observed that we'll wait for some more time for him to appear.
So you have not yet confirmed the service.
This was fixed for appearance today of the.
Has service been?
Yes, my lord. Service has been affected, my lord. We filed an affidavit,
You have filed the affidavit.
my lord, on 6th of November, my lord.
My lord, in fact, when the writ petition, I appeared only for one of the petitioners. My lord. I did not appear for the other.
Are they related, or
No, my lord.
I mean, do they know each other, or are they in contact?
No, my lord, they are from two different places. One is from Bihar, one is from Bengal. My lord, the other petitioner, my lord, he has already got a job in the railway department.
Whatever the case may be, see, more often than not, the court would not look into the go ex parte against any party without giving them opportunity.
So as per the last order, my lord, today it was fixed for his appearance, my lord, of respondent number 2.
My lord, page 8 of my service affidavit, my lord, that was filed on 6th of November, my lord. Service has been completed, my lord, in fact, to him.
It may have been. It may have been. But how do we page 8 of
Page
your
8, my lord. Lordships can compare that with page 4, my lord. The article number is there, my lord.
what is the
This is it in the last page 7.
page? So this is Rahul
Rahul Chakravarti, my lord.
Chakravarti.
Page 4, your lordship will see the postal receipt, my lord. Here number is given 4178 at page 4, my lord. At the top, my lord, RE 4178197222, and page 8,
This is the consignment number.
my lord, and page 8 is the confirmation by the postal department, my lord. Article number is 417822, and it says, my lord, as per tracking, the article was delivered on 17/10/23 by Malikpur Sub Post Office under West Bengal Circle.
We'll give him another chance to appear. What is the matter about Mr. Doctor?
This is regarding appointment, my lord. The learned single judge has directed us to appoint him in certain post in Nigrims, my lord.
Okay, but
They appoint the petitioner.
but now
I am
you say that he
representing
has already got other appointment.
Number 2, he got
So
another
he
appointment.
may
my lord.
not be interested.
My lord, direction is the single bench was, my lord, only to appoint me, my lord. The petitioner I am representing, my lord. Here, of course, there
Or
is
not?
one.
Okay, not the other one.
My lord, even at that point, it was brought to the notice of the court, my lord, that the other petitioner, my lord, he is not going ahead with the matter.
Well, here, my lord, what happened? One person after joining, he resigned, my lord. So one vacancy arose, my lord. He was waiting list number 1, my lord. The petitioner number 1.
But my contest
But
is
that
not that.
would that situation be covered by the impugn order?
My lord, impugn order has observed, my lord, that number 2 petitioner number 2 is not interested. That observation is there, my lord.
If that is there, then what remains?
As far as number 2, my lord. But we are agreed by direction to appoint him
But
also.
you have, why have you arrayed him?
Because he was petitioner number 2, my lord. That's why we were read. Because he was not because how it happened, my lord, because the court, the hearing proceeded on the basis that Mr. Bhattacharya is appearing for both the petitioners, my lord.
My lord, what had earlier happened, my lord, this writ petition was filed by a counsel from Guwahati, my lord. That time, both the petitioners were being represented. Subsequently, my lord, I was engaged. So, my lord, I appeared only for the Wakalatnama that I filed, my lord, was only for Vikas Kumar. However, I brought to the notice of the Honorable Court that the other person is not interested in the matter because he already got a job. I think he posted somewhere in Assam at the moment.
Is that confirmed? Of course,
My lord, in fact,
nothing can
he
be
spoke to me also, but
nothing
then
can be said.
if my lord wants, then should I leave it to
That you see, that aspect has to be first confirmed.
or else, my lord, it can be that if the next date he is not appeared, the case will proceed.
Dr. Muziga, the SGI appearing for the appellant has submitted that is there an application? This is an application for condonation.
Condonation also there. It can be taken up with the next statement.
For the applicant, appellant should be applicant.
Delay of 37 days.
We'll take it up next week. Has submitted that the service of notice upon the respondent number 2 has been duly effected and affidavit of service has been filed for this court. However, for ends of justice, this court has prevailed upon the parties to allow the respondent number 2 to appear before this court today. In spite of such direction, the respondent number 2 has failed to appear. Be that as it may, the DSGI has submitted that one more opportunity may be given to the respondent to appear before this court. On premise, this seems allowed. This is matter of the 1 week. The respondent number 2, if he fails to appear, then the matter shall proceed ex parte against him.
Deeply.
Second call from supplementary cost list, item number 4.
My Lord, I will not take a long time. May Lordship allow me to point out certain facts, and I will place some authorities to support my contention. To begin with, my Lord, the admitted fact is the learned single bench in the first writ petition did not set aside the NIT, but caused the Mr. Kendia appointment and make an observation to the EC, Executive Committee, to reconsider, relook into all these aspects. Now, pursuant to this, my Lord, I just to refresh, my Lord, a few facts, my Lord. Then or we kindly see, they relook into the matter, and page number 88, my Lord, page number 88, though I have shown yesterday, Lordship has seen too, page 88, my Lord. This offer was, my Lord, letter was issued to me.
Letter dated 26
October, after High Court direction. Now, when the High Court gave a direction to the EC to look into, my Lord, NEC was, the NIT was very much in existence. Finalization made by the Tender Committee was very much in existence. And in that writ petition, Tender Committee was not a party. Because the reason why we did not make them as a party, because under the NIT, their duty was performed already. Technical process, financial process completed with the recommendation. Now the duty of the EC was left. Now the duty of the EC was to issue appointment letter, offer, and execute the contract. That is, these two duties are the duties of the Executive Committee, District Council, we can say District Council, not the Tender Committee. So we did not implement the Tender Committee. Knowing this very well, my Lord, learned single bench directed the EC to look into and keep in mind this. Before you give allotment, order is very clear. Before you give allotment, you reconsider this, relook into these aspects, and take a decision. Now, at that time, my Lord, my humble submission today is, at that time, if the EC comes to a conclusion that this Mukuntur highway in Mukuntur is no longer feasible both sides, it creates a traffic impasse, and therefore it violates the norms of the government, central or state government. And if they take a decision to shift, that is another case. They didn't do this, but they examined the matter thoroughly, and they took a decision that yes, you are a highest bidder. You are asked now to give a proper land, arrange a suitable land, and within 2 months, so that the appointment letter and execution will come. Now, District Council, the Executive Committee did not ask me to give another land, another place, because the District Council EC has also no power to go beyond the Mukuntur, so also me, also. Therefore, there was an internal complaint, and District Council asked, therefore, instead of left side, the right side is better. And because of that, my Lord, he has given the reply to that one. And even if I have put the offer, the Tender Committee visited the place before finalization technical process. They finalized everything, keeping in mind the lay-by and other norms, and they finalized. It is there, but since you raise objection internally, other side also, Mr. Kende, the land offer by Mr. Kende is the lease is with me. Here also I can give. That was the offer. Now, thereafter, my Lord, the offer letter is page number 89. Thereafter, what happened? This we have submitted on 24th November. 24th November, and EC, Lordship kindly see, Executive Committee took a decision, my Lord. I will come to page number 100. With Lordship permission, I'm trying to make out a case here. There is no question for challenging the shifting, my lord. Now, page 100, my lord. Lordship, I invite Lordship to attention to page number 100.
Yes.
This was the minutes adopted by EC on 14 March. Now, when we see this, the minutes, my lord, here they discuss the legal notice issued by Mr. Kindia. There was no deliberation of, my lord, keep in mind, my lord, there is no deliberation that there would be a traffic impasse in Mukundu. It never discussed. It is not. Well, the free flow of the traffic, including VIP, would be disturbed. It is not there. Number 3, my lord, there would be a violation of the norms laid down by the state government on national highways. It is not there. The only discussion is that, my lord, Mr. Kindia has issued a legal notice. And if we accept his land, the one he offered, that would amount to deviation of the norms of the NIT. That was the legal opinion they received. So EC deliberated upon that. And EC has taken a decision in view of that. Legal advisor advised the EC not to proceed with the appointment with the writ petitioner. My lord, that one, may I just read out the second paragraph, the last part. The legal advisor has therefore justified the issuance of the legal notice.
Just a moment.
My lord, page number 100, my lord. 1, 2, 3, 4. 4 lines from the second paragraph of that page 100.
Yes.
The legal advisor has therefore justified the issuance of the legal notice and has advised the executive committee not to proceed with the issuance of the appointment order to brother-in-law at an alternative location, that is Mr. Kindia place. And in the event a process of the appointment is initiated, the executive committee should recall the same. The executive committee in its earlier decision dated such had resolved to offer appointment to brother-in-law provided she makes necessary arrangement suitable to its site to operate the checkpoint. Here, 18/10/2022, that was after single bench direction. They resolve. Now, because of the fresh legal notice, they reopen their mind and they are observing this. Now, persons thereto, provide letter dated such, decision dated such was also communicated to Ritalin. Upon deliberation and discussion and on examination of the legal opinion of the legal advisor, the executive committee has therefore resolved the following. The earlier executive committee decision dated such is hereby recalled. The executive committee, a secretary executive committee shall communicate to stream brother-in-law regarding recalling of the earlier decision, and that the latter dated such communicate to stands cancelled. The executive committee hereby entrusts the CEM and EM in charge taxation to work out the manner and mode of appointment of an agent of the council who shall operate the check station on behalf of the council, my lord. These decisions, my lord, these 3 decisions, number 1 and 2 is the cancellations. On what basis? On the basis of the legal notice. And number third point also, entrusted to CEM. They never take a decision that we will go to clemency. That in view of this legal notice, you look the matter now to work out the mechanism, how to go about, whether the department can run or not. That was the decision. Now the basis is what? The basis is the legal notice. Nothing. It is not because of the violation of the national highway norms. It is not because of the traffic impasse in the Mukundu, left and right. It is not because any other reason, only because of that. And learned single bench, when we challenge this, learned single bench clearly held that Mr. Kindia doesn't have local standing. He becomes a stranger. Therefore, on the legal notice received from the hand of a stranger, you cannot cancel it. That was the ground. Therefore, the question I pose to myself is, how do I challenge that they are going to clearish. On the ground of what? On the ground of, my lord, the Mukunduri has a traffic impasse. There is no such decision of the EC. Therefore, the only reason cancelling my appointment, my offer, tender process, is only because of the legal notice only. Legal notice. And in view of this, this is the foundation. This was on 14 March. Now, after 2 days from this, they issued the impunity order. Now, impunity order is, my lord, page number, my lord, may I take it? Page number 90A, 90A. Lordship, can I see the reason? Then I will place few decisions to support my lord. What is the reason on the face of this impunity order?
Is 90?
90A.
That's a type copy.
Type copy, my lord. Type copy. My lord. Now, may I take subject executive committee decision dated 14/3, which we read out. This is the basis. They are referring to that one. Now, my offer also the record now. I am directed to inform you that the EC KHHC Jawai in its earlier decision dated such had resolved to offer appointment to you to operate the council's check station at Mukundu, provided you make necessary arrangement for a suitable site to operate the checkpoint. The said decision of the executive committee was communicated to you by letters and such. In a subsequent development, one of the tenderers had issued a legal notice on the ground that if appointment is given to you for operating the checkpoint at Mukuntur by changing the site not originally offered by you at the earlier time of submission of the bid, the same would again be against the tender condition, the comments, and the terms and conditions stipulated therein, and it was impressed upon the executive committee that any action in that regard would lead to fresh round of litigation. Therefore, the executive committee in its meeting held on 14/3, upon deliberation discussion of the matter, had decided to recall its earlier decision dated such, and accordingly, as a consequence thereof, the letter and the reference is hereby cancelled. The only reason is, my lord, because of the legal notice. There is no ground, my lord, reason reflected that because of the traffic jam in Mukundu. There is no reason, ground reflected that it is because of the violation of the norms set by the government. There is no reason. The traffic issue comes into picture, violation of the state norms comes into picture, my lord, through evidence. State evidence. Now, may I cite one 2016 decisions. My lord. I submitted this support regarding this issue. 2016 volume 1 ACC.
2016.
My lord. 2016 volume 1 ACC page number 724. Relevant paragraph would be paragraph 4, my lord. Paragraph 4, my lord. May I invite Lordship attention to paragraph 4. May I read, my lord?
Yes.
There can be no gainsaying that every decision of an administrative or executive nature must be a composite and self-sustaining one, in that it should contain all the reasons which prevail on the official taking the decision to arrive at his conclusion. It is beyond cavil that any authority cannot be permitted to travel beyond the stand adopted and expressed by it in the impugned action. If precedent is required for this proposition, it can be found in the celebrated decision titled Mahendra Singh Gill versus ECI, of which the following paragraph deserves extraction. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned, and it cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, at the time it comes to the court on account of a challenge, get validated by additional grounds later brought out. we may here draw attention to the observation of post-justice in such. Public orders made in exercise of a statutory authority cannot be construed in the light of explanation subsequently given by the officer taking the order of what he meant, or of what was in his mind, or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed, and must be construed objectively with reference to the language used in the order itself. But the order, it is therefore I cite this decision to persuade my lord that the grounds mentioned in this impugned letter and the minutes 14 March and this impugned letter 16 March, the ground is what? The ground is the legal notice. No other grounds. Now here the respondent tried to make out a case, different case, that it is because of violation of national norms. Omokundu, there is a traffic jams. It is not technically fit. There is no such ground reflected. Therefore, the learned single bench, my lord, learned single bench had set aside this 16 March communication. The ground reflected here is incorrect because Mr. Ginde is no longer in the fray. He is a non-party. Therefore, you cannot act upon the basis of a legal notice received from a stranger. But the moment this is set aside, the minutes of date 14 March also, the same thing, the same ground. What goes? What goes? Therefore, my humble submission is, if learned single bench refuse to interfere with, then that is another case. But he, my lord, objectively, my lord, set aside by exercising his power, equity jurisdiction. My grievance was only that once you set aside, the foundation, everything is taken away, then the consequential will be the relief which we pray for. That need to be considered. But he, my lord, learned a single bench declined to consider that point and went to exemplary course and others. And now may I just cite one more decision, that once the ground of the order is set aside, whatever action subsequently taken in future, it doesn't stand. Let me just cite one judgment. That is 2011 volume 5, ACC. My lord, page number 142. Relevant para would be, my lord, para 33 and 34. 32, my lord. May start from 32 to 34 in short paragraphs. My lord, with lordship permission, may I read? May I start from 32, para 32. It is a settled legal proposition that if initial action is not in consonance with law, subsequent proceedings would not sanctify the same. In such a fact situation, the legal maxim such and such is applicable, meaning thereby, in case a foundation is removed, the superstructure falls. In the case of such and such, this court observed that once the basis of a proceeding is gone, all consequential actions or orders shall fall to the ground automatically, and this principle of consequential order, which is applicable to judicial and quasi-judicial proceedings, is equally applicable to administrative orders. As in the instant case, there had been no proper initiation of this proceedings after the first round of litigation. All other consequential proceedings stood vitiated, and on that ground, too, no fault can be found with the impugned judgment and orders and such. But I cite this law, if I understand properly, that when the learned single bench set aside that the foundation of your executive committee decision and notice on the basis of the legal notice is taken away, whatever subsequent decision taken by district council, maybe they are shifting to Kalidarachi or Karambani or wherever. My lord, according to my humble submission, it follows. It follows. That is what the law I understand from this judgment. Therefore, my lord, it is my humble submission regarding this point, that till today, my lord, there is no order, a separate order that shows that because of on this ground of the violation of the highway norms and others, we have shifted to clearance. It is not there. The subsequent action taken by the exit committee or the EM in charge or CM shifting to clearance, these are all subsequent. If the learned single bench did not take away this impugned order, then consequential orders remains. It valids, subject to challenge by any party, especially me. But once the basis is taken away by the learned single bench, my lord, shifting to clearance is illegal. It is non-est, my lord. That's what I understand from this.
So shifting to clearance was subsequent to the order passed by the single bench.
Yes. Exactly. Lordship, kindly see it is Lordship, I'll just show. Lordship, single bench order might just come. Lord. Single bench order is, my lord, page number 75. Lordship, kindly see. The order was passed on 26 November 2022.
26 September.
September, I'm sorry, stand correct, I'm sorry, I'm obliged. September
22. Yes.
22, my lord. And thereafter, my lord, the date sequence, my lord, it is my duty, my lord, to assist with my lord, my assistant is clear or not. I try my best, my lord. And then thereafter, my lord, page 88, my lord. 88 is the offer. Prior to that, they have quoted that on 18 October, they have decided to give us the appointment. In pursuance to that, they issued this 26th October.
That is
22.
Okay. Reference to the High Court order was.
Yeah, High Court order. High Court order. And thereafter, my lord, in response to that, page number 89, 24/11, I have given my response. Well, till date, there is no decision to shift to clearance. And thereafter, my lord, EC resolution, EC my notes, page number 100. Lordship, kindly go to page number 100. This was, my lord, 24 March 2023. My lord, 14 March 2023. 14 March 2023. Till date, my lord, there was no decision to go to clearance. There was no deliberation at all. What they deliberate is a legal notice only.
But this issue of legal notice was also already subject matter of the, or was taken up at the in the impugned order.
Impugned order. Impugned order. Exactly.
Then it has come again here.
And my lord, impugned order. This the reasons reflected in these minutes, 14th March. This was reflected in the impugned letter.
Okay.
That is page number, my lord. Page number 90, type copy A.
So they've taken cognizance of the fact that the learned single bench has done away with it.
He comprehensively dealt with this issue.
Right.
Dealt with this. And there was no decision to go to clearance reflected in this paper, in these documents. Now, therefore, the entire basis this was taken away, my lord. The subsequent decision, whatever they did, either they want to shift to, my lord, Radhachara, Karambani or Sunapur, whatever. My lord, these are subsequent actions, my lord. Subsequent actions. Therefore, my humble submission is that Supreme Court decisions, when the learned single bench in exercise of its equity jurisdiction, taken away the foundation of in that process. Now, district council needs to, my lord, need to award the contract to be. And the lands are still available, left and right. Even if they want to appreciate that amounts to deviation, third-party complaint. For example, a failed candidate still complain, despite setting aside his appointment.
See, just let me be clear, I'm still confused here. By the impugned order, that issue of the legal notice has been dealt with. So, again, by the impugned order, was your the confirmation or your selection confirmed? by the impugned order.
Yes. But this impugned order is against me, and the learned single bench set aside this one. The reason mentioned in the impugned letter, which is against me, is incorrect.
Yes.
Learned single bench says that District Council EC cannot take a decision on the basis of Mr. Kindia, who is no longer in the fray.
So what remains is, since the EC cannot take cognizance of that legal notice, so the order, the decision to award the contract to you remains.
It remains.
I think that was also observed.
But it remains.
Other consideration came, in the impugned order.
But other consideration is in the first writ petition.
Now, in view of that, if you say that your appointment or your selection is confirmed by this, this resolution dated
14 March.
14 March.
Yes.
Your selection was cancelled.
Well.
So that won't give rise to a new course of action.
My lord, that on the basis of that 14 March, they issued this 16 March letter, same ground, and that was set aside in the forward by the learned single bench. So all the grounds deliberated by the EC in that minutes and letter, my lord, according to me.
This is 14 March 2023.
My lord, that is the minutes of the EC, my lord.
Yes.
14 March. And on the basis of this 14 March, they issue the impugned letter, that is page number 90A. Type copy, my lord.
Yes, 16.
Type copy.
Yes.
It is the same.
Yes.
The same legal notice they are deliberating upon.
Whatever.
This. They refer to the 14 March resolution. So this reason...
Here the decision to award the contract to you was recalled.
Recall. Because of Mr. Kindia legal notice. And learned single bench say that this is incorrect. You cannot recall this letter, my lord. You cannot recall this letter on the basis of Mr. Kindia letter.
What is the date of the impugned order?
Well, the impugned order which the secondary petition is, my lord, page 100, the 90A is a type copy.
The order of the...
learned single bench. I'm sorry.
11.9.
Page 123. And I'll come to that relevant paragraph.
No. This was the earlier. This 26/9/2022 was the earlier.
Yes, that was the earlier.
That is where the confusion.
Madam. That because of that observations, it appears that confusion is created.
Fine. Now.
And my respectful submission with regard to the first decision also, my lord, that the executive committee was asked to directed to look into. Admittedly, the finalization of tender is on record, on the table. NIT was not yet set aside. Only learned single bench make an observation that you keep into all these aspects, traffic method and others, since it is reflected in the affidavit, and set aside Mr. Kindia appointment. Now, District Council, the EC look the matter afresh. What I'm submitting from the beginning. Look afresh. And they are looking afresh, my lord. They are not going beyond the NIT. Because they know very well that NIT is still sustained. It is still there. Recommendation of the expert committee is still there. The tender committee is still there. Therefore, after examining all this, on 18 October 2022, they decided to offer a letter of appointment to me. And in order to achieve that one, on 26 October, they issued the offer letter to me, that you give the suitable land, so that we will finalize the contract. So far as with regard to observation of single benches, my lord, ends up there. So the learned single bench has asked them to apply. They apply their mind, my lord. And Mukundapur remains suitable. Because they never take a decision that Mukundapur is no longer suitable because of traffic jams, impasse in others, violation of state norms. You cannot offer land there. You offer different land. They never do that. They cannot do, because the NIT process is on. What is left to be done is only two steps: offer up an appointment letter and the execution of the agreement only. To do that one, they want to ascertain the land. Now my first land is still there, which is certified by the expert committee, tender committee, having a proper lay-by. And in view of the insistence internally, like we also say, okay, other side also, Mr. Kente no longer in the fray, he is no more. Other side, the left sides, opposite only, from here to here only, same thing. There also lay-by is there, here also lay-by is there. So only the internal objection is that the staff will cross the highway for verification. These are the internal objections. And the offer made by me, the premium, is too excessive. My lord, that was not the duty of the inspector, licensing officer. And the licensing officer was internally briefing the executive committee. And the executive committee was listening. But they said the earlier lessee offered only 32 lakhs per year. Now I offer 77 lakhs. But how it will not benefit, how it will not serve the public interest? It serves the public interest. District Council generating a better revenue. But they say that is too excessive. Illogical. Those observations are there.
Those are not on record.
Well, it is already there. We have an next one.
Okay.
During the first round of litigation. But that chapter is over. Now, therefore, my humble submission, my lord, before I conclude, EC has applied its mind. EC still remain in the Mukuntu. Now the choice is with the EC that I offer left side also, right side also. Then if you have seen the legal notice, in that case, don't accept my my offer letter. Go with the land offered by me in the tender process, which is already there, having a proper lay-by. Who prevented the EC to finalize? And I insist for that. I came before this court for that purpose only. But they say that we cannot accept the land you offer in the left side. You go to the right side. So we say, okay, I go. I offer you. This one is one of the options. And they say that, no. They delay, therefore I file it. And now after filing, they come up with the affidavit that, no, we have taken a decision.
Yeah, we've gone through that, yes.
Yes, to go to clarity. Therefore, my basic contention is that, my lord, there was no decisions, there was no ground mentioned in the impugned minute 14 March and the letter impugned letter 16 March that traffic congestions, impasse are not the ground at all. Only the ground is the legal notice to shift. That was once it is taken away, my lord, taken away, whatever decision taken by district council, subsequently, my lord, it doesn't survive, it collapsed together. What the 2011 Supreme Court says that once the pillar is taken away, the superstructure also falls down together. My lord.
Anything else?
But so this is my lord. I will cite one or few decisions, and my friend may take his time. I'll point out, my lord, the other decision. This, according to me, it is a clear-cut case of abuse of power.
What is the citation?
My lord, the citation may I come. 1994, my lord, Tata Cellular, which is one of the celebrated cases, my lord.
Yes.
I'll just refer to relevant para, my lord.
What is citation?
Citation, my lord. 1994, volume 6, SCC, page number 651. Relevant para would be, my lord, para 70 and 77.
70?
70 and 77. My lord, the law has been laid down till today, my lord. The law laid down by this, in this case, is still standing, my lord. Para 70 may take lordship attention to para 70. May take, my lord. Well, it cannot be denied that the principles of judicial review would to the exercise of the contractual powers by government bodies in order to prevent arbitrariness and favoritism. However, it can be clearly stated that there are inherent limitations in exercise of that power of judicial review. Government is the guardian of the finances of the state. It is expected to protect the financial interests of the state. The right to refuse the lowest or any other guarantor is always available to the government. But the principles laid down in Article 14 of the Constitution have to be kept in view while accepting or refusing a tender. There can be no question of infringement of Article 14 if the government tries to get the best person or to the best quotation. The right to choose cannot be considered to be an arbitrary power. Of course, if the said power is exercised for any collateral purpose, the exercise of that power can be struck down. But may I come to paragraph 77, just to save lordship time. Well, paragraph 77.
Yes.
May I read, madam? The duty of the court to confine itself to question of legality, its concern should be, the law laid down, my lord, read court, whether a decision-making authority exceeded its powers, committed an error of law, committed a breach of rules of natural justice. In my case also it is there, not, but my lord, leave aside. Reach a decision which no reasonable tribunal would have reached, or abuse its powers. Therefore, it is not for the court to determine whether a particular policy or a particular decision taken in the fulfillment of that policy is fair. It is only concerned with the manner in which those decisions have been taken. The extent of the duty to act fairly will vary from case to case. Shortly put, the grounds upon which an administrative action is subject to control by judicial review can be classified as under. 3 points are there. Illegality. This means the decision maker must understand correctly the law that regulates the decision-making power and must give effect to. Irrationality, namely unreasonableness. Procedural impropriety. May not continue. Now, the learned single pen cited this judgment also and set aside that impugned letter. But the reason taken by you on the basis of mistaken there is illegal, irrational. Well, irrational. Therefore, this is one of the decisions. This one of the decision. Another decision may cite is the last decision, 2012 volume 8, ACC, page number, my lord, 216. Relevant para, may I say, my lord, 23 and 24. And 24. This is the last citation method I made. Para 23, may I start? Yes. From the above decisions, the following principles emerge. The basic requirement of Article 14 is fairness in action by the state, and non-arbitrariness in essence, and substance is the heartbeat of fair play. These actions are amenable to the judicial review only to the extent that state must act validly for discernible reason and not whimsically for any ulterior purpose. If the state acts within the bounds of reasonableness, it would be legitimate to take into consideration and national priorities. Fixation of the value of the tender is entirely within the purview of the executive, and the courts are hardly have any role to play in this process except for striking down such action of the executive as is proved to be arbitrary or unreasonable. If the government acts in conformity with certain healthy standards and norms such as awarding of contracts by inviting tenders, in those circumstances, the interference by court is very limited. In the matter of formulating condition of a tender to government and awarding contract, greater latitude is required to be conceded to the state authorities unless the action of the tendering authority is found to be malicious and misuse of its statutory powers. Interference by courts is not warranted. Certain precondition or qualification for tenders have to be laid down to ensure that the contractor has the capacity and the resources to successfully execute the work. If the state or its instrumentalities act reasonably, fairly, and best public interest in awarding contract, here again interference by court is very restrictive, since no person can claim a fundamental right to carry on business with the government. Therefore, a court, before interfering in tender or contractual matters in exercise of our judicial review, should pose to itself the following question: whether the process adopted or decision made by the authority is modified or intended to favor someone, or whether the process adopted or decision made is arbitrary, so arbitrary and irrational that the court can say the decision is such that no responsible authority acting reasonably and in accordance with relevant law could have reached, or whether the public interest is affected. I mean, not,
It's all general proposition. Which way it is applicable in your case?
my lord, in
These
my
are propositions we follow every way.
well, but that is true. My lord, therefore, the learned single bench, my humble submission, learned single bench, the reason adopted by the EC is irrational, is illegal, unreasonable. That was taken away. Therefore, my submission, once that is taken away, the only issue issue need to be considered by learned single bench is to relief part. But if he refused to take away those grounds, my lord, that is another issue. But by applying this law, my lord, my humble submission, my lord, the learned single bench found that the reason adopted by the EC and the EC reflected in the minutes and the impugned letter is illegal, in violation of the settled procedure of law, like Lordship has correctly pointed out. But, and therefore,
All that goes in your favor only.
in my favor, Therefore, my humble submission is it is a case of open, my lord, open and naked abuse of process of power by the district council. That was not up refused to accept by the district council, by the learned single bench. Our contention was up here. The only, my lord, the learned single bench was short of granting the relief I prayed for. Therefore, it was a fit case. Once the actions of council is irrational, illegal, arbitrary, my lord, learned single bench ought to consider my prayer, and I humbly prayed for that same thing. And alternatively, yesterday also Lordship, Justice P. Bhattacharya has pointed out that my alternative prayer, my lord, I invoke the rich jurisdictions. Is the equity jurisdictions? Is the your Lordship discretion jurisdictions? It is not my right. I must be fair in my prayer when I come before this honourable court. Therefore, if my first limb of submission is not persuasive to you, to my lord, convincing to my lord,
Power is not always discretionary. You
It
have
was
the right
discretion.
also. You can come and say that is my claim. Why?
my bad,
It is not always discretion.
my lord, my lord, coming to court is my rights, my lord.
Judgment is not correct.
Coming to approaching my before this court is my right. But whether to grant relief or not, it is Lordship discretion. What I mean,
That is a difference.
right.
Then it is not always exercise of discretionary power. Sometimes red code is bound. If there is a clear-cut violation
Right.
of fundamental and legal.
Right. Correct.
Okay.
Correct.
Now in the process of tender,
Right.
what is your right?
Right.
That is to be ascertained
Yes.
on the basis of the facts.
Right. Correct. And but the law is very
Now,
clear.
Say supposing if you say that this tender condition has been violated, or say like EC has not proceeded in accordance with it, you have to come back to the first order passed by the single judge. Now single judge has created some leverage, give it some leverage. It is, see, if you come to the direction passed there, which has not been challenged by you,
Yes.
and this was passed in a case which you filed,
Yes.
so that decision is binding on you also.
Right.
If you come to that, just come back to that just for a while.
Yes.
For our satisfaction, come to page 86.
86. Yes, I'm in the 86, my lord.
This comes paragraph 14.
Paragraph 14, my lord.
See, what is, just read it. It is further provided that
It is further provided that the NIT did not prescribe specific criteria or requirement to meet the norms of setting up toll stations. The respondent number 3 is directed to relook at the decisions, especially the process thereof, before any decision of allotment is taken.
just pause a moment.
Yes.
Which way you interpret this
Right.
observation?
That
Means even the single judge at that point of time found that the stipulation made in the NEET
Yes.
also had some lackings, and EC was given liberty to correct it. Now further proceed. Then again, you further proceed.
I may further proceed. It also been brought to the notice of the court that there have been a subsequent development whereby the state government have issued certain orders which have a bearing on the operation of such check stations. All these considerations shall also be taken into account when the state respondents review the decision, as at the initial stage itself, this court had held, well, this may be another one.
So that is also there with them.
Absolutely, I
By
found
virtue
them.
of the court's order.
Well, by virtue
And
of the
you
court's
cannot
order.
dispute it. Now the first citation which you have referred in 1994, oh sorry, that 2016,
16.
wherein you have said, let's say supposing if a certain impugned action is
Yes.
based on certain aspect,
Right.
the same cannot state modified at a subsequent stage
Right.
by filing an affidavit, whereby you enlarge the
Yes.
you see like the grounds for
Yeah, the
FIR,
grounds of.
and court should not act on that.
Right.
Court should strictly, basically, rely on the or the dwell on the grounds which are taken in the impugned order. Now, say for your case, if it is a condition of need, now you cannot come and say that now. By virtue of the fact, the single bench order has given some leverage to the executive committee to modify.
Well,
Okay, so in view of that, you cannot come and say that this impugned action suffers because it is not in accordance with the terms of it.
Right.
The second point which you said, well, do not take it as a view expressed by the court. These are
yes.
queries coming from.
Yes, yes.
Now, you said that the resolution of the executive committee, the impugned decision,
Yes.
resolution dated 14th,
Yes, for
it is based on a legal notice.
legal notice.
Accepted. We say that okay. But then what is the contents of the legal notice?
Legal notice.
Contents of the legal notice is that if you gave, see, legal notice was addressed by a person who was not disqualified.
Yes.
He was an unsuccessful bidder.
Yes.
But then he was not a disqualified bidder.
Right. Right.
Okay.
Right.
So definitely, if any extra privilege is given to you in terms of negotiation, then that the same privilege has to be given to him also.
That is true.
Now,
That
if
is
you are given some you see, opportunity of negotiating with regard to the altering your place, then he also should be given a chance to change his quotation rates. What is wrong in it?
My lord. That was the reason adopted by the EC on 14.
So that is
On
what-
14.
so that see say suppose you see, you know, settled position. You see, tender cannot be settled on the basis of personal negotiation. That is barred.
Well,
Stipulation made in the
yes, yes.
technical committee is there.
Right.
By technical bid, financial bids
Yes.
are there, committees are there.
Right.
Okay.
Right.
And that has to be decided strictly in accordance with the conditions stipulated.
Right.
Now, for this case, may not be strictly just because for the reason of passing of the earlier order with the single bench.
Right.
Okay.
Right.
But then, by virtue of single bench order, if some benefit is extended to one of the bidders, then why not same benefit be extended to other bidders?
Right.
The single bench did not say that they should only negotiate with you.
Yes. It is.
Relooking of conditions, and you see, deciding according means if they relook and if they relax some conditions or create some more opportunities, this opportunity should apply to each and everyone,
Right.
not only to you.
Right. Right.
You will just never say it that you are the only person who should
Right.
do it.
Right.
So why that negotiation should be confined to you only?
Right.
Why not to others?
Right. May Lordship permission, may I reply? Two important queries Lordship is making. With regard to that extension of certain privileges, Lordship is making that question to me. But it's my duty to respond. My Lord, Mr. Kindia, if he's still in the fray, my Lord,
This is
then
not a question of in the fray.
he is entitled. But now his appointment was admittedly set aside.
Yes.
Set aside. Once it is set aside, he has no more rights.
You want to say he will stand disqualified. So it means your interpretation would be that
Yes.
that if after his settlement is set aside,
Yes.
he is nowhere. He doesn't remain free.
Well, he's
And
no
then
no.
thereafter, the executive committee would be at liberty to give some extra advantage to you.
No,
I don't think
he
single
could
bench
have-
has anywhere said it.
single bench did not say that one. Single bench did not give a favorable observation in my favor.
See, if
It is general
there is
observation
if
only.
there is a private, see, if there is a negotiation with you, even with regard to the change of altering the place from left side to right or right side to left side, this is a personal negotiation. Now, for the offering of place is a part of this thing, technical bid.
Yes.
So it means you negotiate. You have been given an opportunity to negotiate. So we'll say why not then the other person also. the person who addressed the legal notice, should also be given an opportunity to file his bid again.
The bid.
You see, equality, let him be also with this thing.
No,
Because
Lordship
it is
is,
part of personal negotiation.
Lordship, therefore, my humble submission is, Lordship is correct. Learned single bench in the first round did not give any favorable order in my observation in my favor. It's a general observation.
Applying to each and every.
Applying to everyone. And if they adopt a resolution, taken a decisions, that in view of that, we apply our own, and we have decided to go to clemency, for example. That is different, different grounds, different case result. Now, after single bench observation, the EC knowing very well that the expert findings are there, reports are there, therefore they are not, my lord, if the EC, even if EC is directed, I don't think, my lord, my humble submission is that single bench direction is to ignore the expert committee, the tender committee, findings and the records, and EC altogether, you look the entire matter afresh, ignoring everything, as if there is no tender process. That was not the intention. The direction of
where is the boundary? Just tell us. It will be you to interpret that paragraph 14.
Paragraph 14.
Now, this paragraph 14 says that he did not provide specific criteria and requirement to meet the norms of setting up post stations.
My lord, here NIT.
Now, if that is the thing, then definitely EC had the power to set the specific criteria.
And therefore, the lordship is correct. NIT, my lord, lay-by is not mentioned. But the expert committee, when they come for inspection of my site and can they cite other gentlemen also, they found it. Ample spaces are there, lay-bys are there, therefore they allow. Now, lordship, assuming that EC has given a privilege to relook into the matter, they have relooked it.
They have relooked it. We are in the process of relooking. They have taken into consideration that legal notice, and then they have gone by it.
My lord.
Okay, now gone by it, and then that thing comes.
My lord.
The same thing that, yes, why should you be given a scope of personal regulation?
Lordship.
Why not others?
Right, lordship. Now EC has applied its mind. Well applied its mind, my lord. They are not saying that because of this, the jam, the highways.
No, we are not.
They are only the legal notice.
Legal notice.
Legal notice.
That part you have already addressed.
My
you have already said.
My lord.
We go by this thing we have noticed.
Right. Legal notice,
that,
lord.
That yes. This impugned order, impugned resolution, nowhere speaks anything about the traffic jam.
Yes,
so we are ignoring that.
My lord.
Just confine yourself to the legal notice and the
legal notice. Right. Legal notice I will confine, my lord, because the EC also confined with that. Legal notice.
Yes.
When they adopted on 14 and 16 letter also, and learned single bench held that it is incorrect. It is illegal. On the basis of a legal notice received from somebody else, you cannot recall
Not
this.
somebody else. He was a participant in the tender.
My lord, that brilliant paragraph, may I just point out?
No, see, say supposing
it is there. But learned single bench in the first in the impugned judgment here, he has dealt with. I'll just lordship bear with me
as far as
to point out that brilliant paragraph.
Locus is concerned.
Yes, my locus is concerned. My lord, if lordship allow me just to point out this.
Will each and every finding of the single bench bind us? Can't we take different?
My lordship.
No, what we understand in the tender process, if you are given any chance of personal private negotiation, then others also should be given chance. Which way you deal with this?
I'm not saying that the lordship power is restricted.
No.
My lord, this is one of the most powerful bench, division bench in the High Court, and therefore, lordship,
that is the
single bench finding is not binding to you.
You apply your judicial mind. You see, you apply your legal mind.
Yes.
Into a matter, tender process. Each and every participant should have equal opportunity.
Right.
No order of the court should create a special opportunity for any of the participants.
Exactly. Right.
If it is created,
right,
then that order will be illegal to the
my lord.
Now,
exactly.
The earlier round of litigation single bench did not say anything that the EC should only negotiate with you.
Yes.
Then where is the question of providing you another thing, giving you a chance that yes, we will settle with you if you provide us different land?
My lord.
This is see, on that count it goes.
My lord,
It was improper.
lordship,
It was improper. This is his decision. Okay. So before we decide the legality of this thing, the order or the resolution impugned here, we find, or that is rather a prima facie view, subject to what my lord says, of course.
no, it is a healthy
yes,
exchange. Healthy exchange. Well,
that the resolution by which they decided to accept your bid
yes.
after you offered alternative land, that is also illegal. No right to throw on to you on the basis of that.
But that so
See, it is you. You have created that problem by allowing that first single bench order to remain intact.
my lord, I do, my lord, with due respect, there is
The
scope
entire
for.
complicacy is created because of you. You came to the court, you obtained that order.
I obtained that order.
And that, whatever finding is there, that will bind you first before it binds others.
My lord, that observation is there, where there is scope for me to assail before the division bench. I didn't do that. I concede with it. I bow down with that. Now, because of that non-assailing, district council easily has the privilege to apply its mind. They apply its mind. And after thoroughly applying its mind, they give me this letter.
By creating an opportunity.
But-
How just tackle, we are just this court wants a clarification from you with regard to that private negotiation.
But
How much legal it is?
my lord,
Show us some decision where you could have been given.
my lord, my lord, I would not say that it is an internal closed door negotiation. It is not. After persons to court direction, my lord, this is the process was continued.
Why-
And now, my lord,
Why process was confined to you only?
my lord, I was the first bidder. And district council, my lord, knowing that I'm the first bidder and the Mr. Kindia appointment set aside, my lord, therefore they offer, my lord, once the district council, my humble submission, my lordship, kindly appreciate, once district council apply its mind, because of my non-challenge to that part of observations, and adopted the decision, they have applied their mind, and nobody has raised any grievance. And later on, Mr. Kindia issued a legal notice. And on that basis, they pass order. And single bench says no. Kindia picture doesn't arise anymore. They are not challenging. District council is not agree with that finding. That observation of the learned single bench goes against the district council. The basis of the district council decision taken away by the learned single bench.
So do you want to say that just because that unsuccessful bidder had no locus standi,
But lordship is
issue any legal notice?
my lord, lordship is
So
very
the creation of opportunity to you is valid in law.
my
You
lord,
want to say that?
my lord. Only the
So minus say supposing if that legal notice is taken,
Yes.
say supposing it is not there.
yes.
Okay.
Yeah.
That means the negotiation which has district council made with you in terms of selection of the location, can it be termed as valid?
But therefore, in my ground also,
You reply to that. Can it be
but-
termed as valid?
my lord, according to me, my lord, that the offer was there, and I have given a reply. Now that one, the two plots, left and right, are remain there.
We are
Now,
going to
this-
that. We are
no.
going to we are just saying that the very opportunity given to you to offer an alternative land, was it valid in law?
My lord, that is because of the district council insistent in we offer. But my original offer remained the same. It is there, my lord. I never said that abandon that one. They offer the land, I offer
The original offer was
easily.
never accepted.
My lord,
Tender was no settlement was made.
my lord.
It is not that. You see, the blame is entered. The blame is there with them also.
My lord, if
not
I
that
say,
this- You know, like that. Since you have to encounter the court, doesn't mean that
my lord, my lord. Therefore, it is,
they stand at right points.
my lord.
My lord. But then, this is one obstacle that will remain. You see, here you are aggrieved by the order of the single judge only because he did not pass any order for settlement of the contract.
Well,
Now, your claim here is that, you see, otherwise you have no dispute with the finding, all the finding is in your favor.
in my favor.
And we also do not see apparently anything wrong in that.
Right.
At this till that with this point. Now, if you want that there should be, or rather you should have a legal claim to get the settlement, get a contract in your favor, then you have to at least come across that hurdle, private negotiation. Private negotiation.
With that one, may I say, now, therefore, even the specific plea I have taken, if the land I offer was ignored by, I abandon it, district council abandon it and go to another places, and I offer another places, that is another matter. But my offer remained the same in tender documents. I insisted for that because I came before this court. I succeeded partially, I can say, though some the remarks are there. Now, the district council applied their mind and asked me to offer, and they say that the other side is more suitable, so I offer.
You said
Therefore, my humble submission, even now also, Lordship is sitting in the Reed Court, even now. Therefore, the NIT is very, the judicial interference in NIT is very strict. Lordship is very well versed. Once the game is started, terms and conditions of the game cannot be altered.
But then what about this?
That is correct. Now, therefore, may I pray, the only I offer the left side because of the insistence of this council. My original offer remains
wrong. That insistence is wrong.
But insistence is wrong. Therefore, Lordship is sitting in equity jurisdiction. Therefore, I prayed. Therefore, I prayed that if Lordship satisfy my argument, I prayed Lordship direct the district council to settle the contract with me in my original place. That is well within the confines of the NIT. But it is still there with the same lay by.
No,
But
what
that
was,
is
your,
according
what was
to-
your prayer in the first round of repetition?
First round litigation, my lord, that was a prayer.
Repetition, which you were successful.
Yes.
What was your prayer there?
My lord, may I just take that portion with Lordship permission?
So supposing if the prayer is not granted,
yes,
or you omit to make this as prayer, can you renew this prayer now? No. Yeah.
My lord,
In the first round of litigation, if you miss something,
no, my lord, with due respect, at the earlier litigation, my prayer was succeeded. My
What-
prayer,
what was your prayer in the
my
earlier round
prayer,
of
Lordship, kindly see page number 48.
Earlier round of litigation. This is
Earlier round litigation.
Earlier round of
This is the first round litigation.
Yes.
Yes. Page number 48. My Lordship, in the premises of proceedings, therefore humbly pray that Lordship may be pleased to consider the above call for records, issue rules, calling upon the respondent to show cause as to why writ of mandamus shall not be issued, declaring the impugned decision of the exit committee, taken on 14/3/2023, recalling and cancelling the. My lord.
No, this is.
But I'm so sorry, madam. I'm standing correct. May I come to the first one? I'm standing correct.
It's not the next. It's not.
But the first one, my lord, I'm sorry.
You know there is a legal.
My
There is a
lord,
legal part. If you omit to make some prayer there, you cannot make it.
my lord, it is still. I'll just.
The relief which was available to you at that point of time, and if you omit to make that prayer, or rather if you at all had made it and it was not granted, then can you renew the same prayer?
But the relief, my lord, the relief I prayed for, setting aside the appointment of Mr. Kindia, was accepted, madam. This is the impugned order we challenge.
Disorder. But what was the prayer? Prayer in the first.
Prayer in the writ petition. That is the
No, first round of the day.
that is the first round, my lord.
What is the page?
My lord, I'm sorry, I did not annex that page, that first writ petition copy, madam. If Lordship permits me,
You have made reference to the order of the
earlier, Lordship is made inquiry for the prayer made in the first writ petition. First writ petition.
Because you have a specific prayer now that you want settlement to be made in your favor.
And the first writ petition
was
prayer
the
also
prayer
same
there
thing.
also,
It was there.
It was there.
So
It
if
was
that
there.
prayer
Yes,
has not been specifically granted,
my lord. It was not granted, my lord.
then,
My lord, the
then which
impugned-
way you will say that he should be granted it here?
No, my lord, the single bench, I prayed for setting aside the appointment of Mr. Kindia, and number 2 prayer is to direct the council to settle with me. So first prayer is accepted. Second prayer, court did not grant it, but the court allowed the EC to apply your mind.
Definitely. That is
And
for subject matter of reconsideration. By you.
reconsideration is there, my lord.
So
And therefore,
reconsideration is something like, you see, fresh.
my lord, reconsideration is fresh, but
You
it
cannot
can
have any advantage which was there with you at the time when you filed the first application.
There is a bar for you to make a prayer specifically.
It has to be on record.
my lord. Therefore, my prayer,
Can you place before us those prayers and all?
my lord, I'm ready, my lord. I'm short of the copy. May I place it tomorrow or subject to lordship convenience?
We have 2 copies, my lord. We can place it. I have 1 copy in his.
We,
Dr. Mojila, did you cancel this thing?
My lord will not mind.
Please, please.
Have you cancelled this?
My lord, we have taken the impugned order that is.
Have you cancelled this tender process?
My lord, we have said that we will run the check gate at our own at Clayton.
That is a different location. Now you have gone to different location. You are not running any check gate in that same location.
My lord.
What is the status of that tender, NIT?
Tender because of the litigation, my lord.
No, whether it stands cancelled or not.
There is no formal order to cancelling the tender, my lord. No.
So if it is not formal order, how could you shift it? It is not that you have shifted to near place. You have gone to 5 kilometers away.
My lord.
Then that is a change of location. How could you do it?
My lord, that was placed before the single judge.
Is it not that apparent to defeat the thing? The interest of the appellant hearing? That has been done. Your action speaks of malafide. It is apparent. You have not cancelled this tender, and you have moved away 5 kilometers away, and then you allot it to somebody else, and then the court takes a strict note of it. Then
That
you
is
change
not
it, and then say we are running.
The department is
How
running.
can you do it? How we will explain that thing?
My lord,
The single judge has imposed a fine on you.
2 lakh rupees, my lord.
So that is good enough to say we do not have to give any other finding. The court has taken note of your action, and that stigma remains with you.
That
Your
remains,
entire thing.
that
See,
remains, my lord.
you
That
do not
remains,
think
my
that
lord.
you have paid the money or you have offered to pay the money, resolve that thing. Single judge order is washed out. It cannot. That finding you have not challenged, and that will remain with you. We will not take any other view with these things. And then, say, supposing if we are to proceed here with these things, we will take note of that. And we will say that we have not raised any grievance with regard to the finding recorded there.
The earlier round of it is.
Single bench order, which is impugned here.
And we have not filed an appeal against this, my
You
lord.
have not filed. That is what you are happy with the stigma cast on you. You have been fined 2 lakh rupees and you are happily paying it. Why? In a contractual matter.
My lord, to
Why
that,
you have to have this kind of conduct? Just tell us.
my lord, to that extent, we admit, my lord, here what happened, my lord. My lord, as it stands today, because my friend has not read the learned single judge's impugned order in detail. I'll read it at length, my lord. What are the actual findings of learned single judge?
So what we can do before you continue, as my brother has pointed out, I think that copy of the requisition would be necessary.
My lord, I'll reconstruct a copy and supply it to him, my lord.
You do it, and we'll examine. We'll continue it tomorrow or some other day.
Next week, if lordship was subject to lordship convenience.
Yeah. So, but tomorrow we don't have a bench. Tomorrow we don't have a bench. So next week, yeah, because we'll still have to hear.
Yes.
You may respond.
Right.
You have to enlighten us.
My lord.
At least on especially on private legislation. You see, we are at least at present we are in a position we do not know. If you ask for settlement, See, their wrongdoings, definitely it remains, they have not challenged that order also, so that is there, always there. Okay, but so far as your claim is concerned, just think about this thing.
Yes.
Private negotiation, to what extent it can be allowed in. The earlier round of order passed by single bench, no way said that to correct the infirmities in the need and all those things, or the deficiency, they should only negotiate with you. No way.
No, exactly.
So will this
If they
debate?
create an opportunity to you, that should be given to others also.
Will this debate on 7th? Will this debate on 7th?
Sir.
That's exactly 1 week.
Yes.
But I can answer that. My lord, page 88, which he's basing his entire claim on, that we have issued a letter to provide alternate land, my lord. My lord, this letter only says, my lord, if I may just read 2 lines, my lord, this page 88.
Yes.
Therefore, you are requested to arrange a suitable land with lay-by that can be used for the purpose of operation of check extensions, so as not to disturb the movement of traffic along national highway. Kindly note that you are to comply with the requirement of providing land and lay-by for operation of the check gate station within a period of 2 months from the date of issue of this letter for consideration of the executive committee as deemed proper. My lord, this was only a suggestion, my lord. In my humble submission, this letter.
No, you have given an opportunity to him. How could you do it?
My lord, but by the time he did, my lord, we have cancelled. We have set it right, my lord, and we have not proceeded further with this offer, my lord.
This you should not have
Given this letter,
opportunity of private.
Should not have given, my lord.
This is illegal.
This is
That is apparently.
my
There
lord.
cannot be 2 views.
I admit to that, my lord. But this was done, my lord. But this was recalled, my lord. This was not given effect to subsequently.
So wrong was corrected.
Wrong. on 7, ma'am.
And secondly, my lord,
I'll supply the copy.
the land which he alternatively offered, my lord, this is the same land which is offered by Mr. Kindia, my lord.
That's what he said. That's what he said.
Now, my lord, in
Which
the
you-
given scenario, when same land is offered by two of them, my lord.
But you see, in principle, I think you have also accepted the land offered by Mr. Kindia, except the fact that he was the second highest bidder, so it could not be
My
bidder.
lord, kindly observe,
There
my
was
lord.
no traffic jam.
That was
when
at the
Kenya was
point of time. During that period, my lord, the state government issued a notice. Lordship is aware, we have filed a writ petition, your lordship passed a stay order, my lord. My lord, when the subject matter itself is at stake, my lord, all the check gates in Meghalaya run by district council are at stake. There is a state government order to dismantle all this, my lord. And because by virtue of the stay order passed by your lordship, my lord, those check gates are somehow running, my lord. But the entire fate is dependent on that. And now, because you have a stay order, my lord, we again accede to his request and set up a check gate at a place where my lord, state government will again come after us, my lord.
That would, in principle, that would not.
My lord.
We will continue then.
My lord.
I'll submit the original
Please.
writ
Give us
petitions.
two
The
copies, just
pleadings.
we want to see.
I'll do that.
Heard. Mr. H.L. Sangresu, learned senior counsel for the petitioner, for the appellant. The hearing will continue on the next date fix. So 7th, this is matter on 7th.
Deeply obliged.
Deeply.
Please, Your Lordship, I beg to make a mention of part 2 of the hearing list, last item, that is item number 20, Your Lordship. In this case, I was supposed to, to produce the entire case record of the inquiry proceeding dated 7/1/2016, the inquiry report.
Yeah, who is appearing for the petitioner?
So we could not get him, Your Lordship, today.
Let the matter be called up.
Okay, sir.
Please, Your Lordship. Lordship, I beg to mention item number 11.
What is item number 11?
Lordship, item 11 is Iftikhar Uddin.
Yeah, what is the matter?
Lordship, this is regarding that shot round forest in Polo Ground, Lordship. The shot round forest in Polo Ground that which was leased out, and now the government is cancelling the lease.
Or the lease?
Lordship.
Is there any interim order?
No, Lordship.
So what is the fate of the petitioner? What is the fate of the petitioner?
Lordship,
if the lease has been cancelled, then they are out.
Yes.
So,
Lordship.
Anyway, how long?
2 weeks, Your Lordship.
On premium by the petitioner, this is matter to 2 weeks.
Item 12 is connected.
Same order.
My Lord, similar prayer for item 13 and 14.
Lordship.
13, 14?
Yes, Your Lordship. 13 and 14 also.
And what is this matter about?
This is regarding regularization of teacher, Your Lordship.
Regularization?
Yes, Your Lordship.
Yes.
Is there no objection?
On premium by petitioner, this is matter of 2 weeks.
Highly obliged.
14 both. Much obliged.
Chief, I beg to mention item number 4 to 10.
Why? These are
My
very
Lord,
old
the
matter.
Arguing Council is exhausted today. Mr. N. Mojika is exhausted today. So
What
he's
happened?
not in a mind to take up this matter today.
I couldn't get you. You're saying?
My Lord, the Arguing Council, Mr. N. Mojika, he's not in a state of mind to take up this matter today. He's exhausted today.
So, fine. Any objection?
No, Your Lordship, only it will come after, it be 2 weeks or 3 weeks, Your Lordship.
We'll put it 3 weeks. It'll come after vacation then.
After vacation, Lordship, yes.
On premium by the petitioner, not objected to by respondent. This is matter to 3 weeks.
Apply, Your Lordship.
Please, Lordship. Chief, I beg to make mention for item 18, Lordship.
Yes, what is this matter about?
This is a regarding that against the order of the Human Rights Commission, Your Lordship. That's
So, 18?
18. 18 or 19? 19. 19.
You're talking about 18 or 19?
18, Lordship.
Oh, sorry, Your Lordship. I thought 19.
Lordship, if I may please, Lordship. Lordship, the petitioners, yes, Lordship, this is a matter of 2021.
Lordship, this is next, not the matter which I. This is item.
Yes, Mr. Kero, you
Item 18.
19.
This we are talking about item number 18.
18. I'm sorry, Lordship. I thought.
For 18 I am there, my lord. For 18 I am there.
You are there. You are for the respondent.
I was the respondent, Mr. Council.
Any objection?
No, my lord. My friend has communicated to my colleague that they are not in a position to do the matter.
on pre-made by the petitioner. This is matter up to 3 weeks.
I have similar prayer, Lordship, for item 19 as well, Lordship. Lordship, we require some more time, Lordship, to file the rejoinder with affidavit filed by the respondent 3.
Rejoinder?
And then, Lordship, we have to file affidavit of service, Lordship. So,
affidavit of service on whom?
Of the respondent 4, Lordship. Affidavit of service.
Also, for the past 4 months,
Lordship,
they have been asking time for filing this affidavit of service.
the petitioner just recently came from the training, Lordship, so we need some more time, Lordship. Was posted as a training in Goa, so recently he just came, Lordship. So we have sent him a service of soft copies, so we'll just give us a week's time, Lordship, we'll be filing. It was a week's time, Lordship.
And you're talking about an
Rejoinder, Lordship, will be filing, yeah.
rejoinder to what?
To the counter affidavit, which is filed by the respondent 3. Which is filed on
When was the affidavit filed?
on 38/10/23, Lordship, you have received.
Or you are respondent 3?
Lordship, I am for respondent 1 and 2. I am for the Human Rights Commission.
True.
Lordship, the matter is, it's been 4 months that they have been asking time for filing this affidavit of service.
That is a different aspect of the matter, Mr. Hera. The respondent 3 has filed her affidavit just recently, to which they also need time to be, they need some time to file the rejoinder. So we'll have to give them that. As far as respondent 4 is concerned,
Yeah, Lordship, we'll
whether
be filing.
you file the affidavit of service.
We will be filing, Lordship.
Pre-made by the petitioner. This is matter up to 1 week or 2 weeks?
Give us 2 weeks, Lordship, Lordship.
2 weeks.
Obliged. Obliged, Lordship.
Obliged, Lordship.
From supplementary cost list, item number 1.
May I please, Your Lordship? My Lord, this is a bail for in NPS case for intermediate quantities. The petitioner's son, Your Lordship, was arrested, was kidnapped by 6 of the co-accused person herein. 6 of the co-accused for ransom of rupees 5 lakhs. He was kidnapped. The petitioner's son was kidnapped from Sonapur, and however the police rescued him in time near the old Clariat DC office. On their apprehension, Your Lordship, this accused person, petitioner's son, was also implicated on alleging that some contraband items of 15 grams was recovered from the vehicle in which the kidnappers kidnapped the petitioner's son. Your Lordship, this vehicle was spotted in near DC office, old DC office, and the vehicle was at around 4 o'clock, and the vehicle was taken to police station Clariat, and there the accused person, this accused petitioner's son, was also arrested. Other 6 accused also arrested. They were kept in custody, and later on in the evening time, 7 o'clock, they searched the taxi and then they got. It was alleged that I am involved, petitioner's son is involved on the ground that one of the accused, co-accused, he has stated before the police that the contraband was delivered by me, by petitioner's son. So, Your Lordship, this is 15 gram, a little bit higher than small quantity. Now the petitioner's son, who is aged about 20 years, and Your Lordship, he has been in jail for almost 9 months. And as of now, Your Lordship, 4 witnesses has already been examined, and the witnesses which has been examined, they are all hearsay witness. The person who has said that it was delivered by me, by petitioner's son, he is also an accused, and he is not cited as a witness. So all are hearsay witness. Now, Your Honor, leaving aside this evidence part, my only submission is that, Your Honor, this is the 3rd time I am approaching this honorable court. First time, Your Lordship, was since charge sheet was filed, that moment, that time it was not considered. However, now the evidence has already, 4 witnesses has been examined, and I approach this honorable court. However, I withdraw the petition, 2nd petition, and to approach the London trial court. However, the London trial court has not granted the bail. That's why I am before this honorable court
My summation is only that, Your Lordship, 15 grams. My petitioner son is 20 years. 9 months he has already in jail, Your Lordship. And as Your Lordship is this section 37 does not attract in intermediate quantities. So at this stage, Your Lordship, 4 accused person has already been granted. At this stage, Your Lordship, I am only praying to release him also on bail. And Your Lordship has already...
Some co-accused have been granted bail.
Yes, Your Lordship, 4 accused person. And Your Lordship has already in intermediate quantities, Your Lordship has granted bail in two, 3 cases, relying on the... Yes, I am not...
All depends on facts and circumstances.
Yes, Your Lordship, similar fact.
And the complicity
Yes.
of...
Yes.
If the complicity of the accused is made out, then of course.
Yes, Your Lordship. So only on the basis of hearsay witness I have been implicated. The person who has said was also an accused who will not come and depose before the court.
What is the... have you annexed the...
Deposition?
The deposition?
Yes, Your Lordship.
So nothing has...
Hearsay. All these 4 witnesses are hearsay, and the vehicle from which this contraband was detected, this vehicle was already in custody of the police.
Why you are saying that you were kidnapped?
I was kidnapped. My petitioner's son was kidnapped for ransom for 5 lakhs from Sonapur.
So where is the indication, or where is the...
No, they have... The police has filed charge sheet against the kidnappers also.
So
And
the person who were with you, they were the one who kidnapped you?
yes, Your Lordship. I was kidnapped.
And then subsequently they also implicate you in the...
Yes, they
in
implicated
this
me.
thing.
Yes. So 5 lakhs ransom they demanded. However, the police rescued me. From Sonapur, they took me to Clariat, and thereafter the police, it was informed, then police rescued me in time only. However, some contraband, 2 vehicles were there. From one of the vehicles, they said that contraband 15 grams was recovered. And then one of the accused, he said that it was delivered by petitioner's son. That particular accused person has not been cited as a witness in the prosecution. He will not come and depose. And the trend of cross-examination...
And that particular accused, was he also granted bail?
No, Your Lordship, he has not yet applied, or maybe I don't know, because these 4 accused, they are also waiting, because I approached the Honorable Court, and this Honorable Court was not entertained at that point of time. So that's why they are also not moving the bail. And the trend of cross-examination also, you know, he is also in denial mode that he has stated before the police. So considering the length and my age, petitioner's son's age, and Your Lordship, the contraband only 15 grams, that is small than higher quantity. I pray that he may be also granted bail, Your Lordship. And Lordship has granted relying on the decision of the Anjali and Rakesh Singh, and then Sanjay Chandra versus CBI.
Do you have those decisions with you?
Yes, Your Lordship. I have given 5, Your Lordship, these 2 Delhi judgment, and 2 of the judgment passed by this Honorable Court, and 1 Gujarat.
Yes, Mr. Karan, what do you have to say?
May it please, Lordship. Lordship, my friend has not correctly stated the facts. Basically, number 1 point, Lordship, is that the petitioner's son, the accused in this case, he was kidnapped because of a wrong drug dealing. He was one carrying the heroin, the drugs from Assam to Clariat, Lordship. And in the meantime, due to some bad dealings, he was kidnapped by the co-accused in this matter, and a ransom call was made to the father of the accused in this case, to the petitioner in this case, for ransom. Lordship, it was also stated in this case that this person, during investigation, he is a peddler, he's a drug peddler, and he has been peddling the drugs consistently in the different districts in the state, Lordship. So he cannot state that he is innocent or
no.
And there are prima facie evidences to show that he is a drug peddler, and he himself has stated during investigation that he used to peddle drugs in this state, Lordship.
My Lord,
Lordship, if I can take you to...
There is nothing, no indication that I am involved or I have committed any offence before. The charge sheet has been filed. There is no case which is pending against me. I have not been arrested at any point of time. There is no criminal antecedent. This is just a mere allegation. And however, Your Lordship, this will be proved during the trial, and 4 witnesses has been examined. My only concern is that Your Lordship, he is.
Lordship, if I can take your lordships to these submissions are also supplemented by my one of my colleagues in page number 40 of my lord's order.
That point of time. First,
if I may read our lordship.
Page?
Page 40.
Yes.
Per contra, Mr. R. Gurung appearing, learned GA appearing on behalf of the state respondents has submitted that petitioner has not depicted an accurate picture of the case, which is in this case also has been done the same thing. Inasmuch as the accused son of the petitioner is a drug peddler in course of business dealings with some of the co-accused persons, perhaps relating to monetary exchange or consideration, he was not being paid as he has demanded. However, the IO in the investigation has found out that the accused son of the petitioner has admitted that he was handed over the said contraband substance by one accused person who was resident of Karamganj at Tongsan village, and he was to deliver the same to another co-accused in this case, that is Sri Banjab Suklan. Therefore, after handing over soap boxes to the co-accused and on payment being denied to him, he was forcibly dragged inside the car. Hence the allegations of kidnapping. The learned GA first submits that there is clear evidence of connection of the accused son of the petitioner with the other co-accused, and as much as there are called detailed records available, which will show that the accused son of the petitioner is in constant touch to my mobile phone with the other co-accused, particularly Sri Banjab Suklan, is therefore paid as so and so. And based on this, on consideration of submissions made so prima facie on merit, it is seen that the alleged contraband substance was recovered from the accused son of the petitioner, and that he has nexus with the other co-accused persons said to be involved in the case of kidnapping as well as in case of drug possession of the thing. And hence, below is denied lordship. Prima facie lordship has found that there is a case against the petitioner's son lordship, against the accused. And lordship, my learned friend has made submissions that some of the co-accused have been granted bail. Lordship, if that is the case, where is that order granting bail, lordship? That's my first question. And whether because right now, as of right now, there are about 6 co-accused, lordship, and some of them have not been the rigors of NDPS have not been indicted against them.
So you have this order, Mr. Pandit?
Yes, Your Lordship, I will just supply. On 12, I have stated in my paragraph 4 of my petition. I will just supply, Your Lordship, I have that order.
But I think Mr. Kanola,
Lordship,
the CD also has to be.
If the CD and the records.
Charge sheet I have included, evidence also I have
charge sheet. The court would like to have a look at the 161 and 164 statement.
Lordship.
Of course, I think 164 has been recorded.
Yes, Your Lordship. Your Lordship, my only argument is that, Your Lordship, I am also saying that, that will be proved during evidence.
That of course.
Yes.
We're looking at, and your prima facie involvement. Yes. And also the fact that since charge sheet has been filed.
Yes, Your Lordship.
So it means that there is a, prima facie case against you.
Yes.
So in such a situation, you have to, argue your case on merit.
Yes, Your Lordship.
Lordship, as per my limited knowledge, lordship, bail is just for prima facie case to show that if the the accused is involved in the case, not for proving if he is guilty or not.
My learned friend can show, Your Lordship, any independent witnesses who has said that they have seen me delivering, or they have seen that it was recovered from me. Prima facie, Your Lordship, if Your Lordship, I will take.
So what at this point of time, I think please.
Record may be called.
Bring the others.
Yes, I will just.
Also, I think so. Even the records or the list of witnesses will also be required.
Oh, here list of witnesses is here in the charge sheet.
Charge sheet.
Yes. List of witnesses.
Yes. In the charge sheet.
Call for the copy of the case.
Copy of the
case diary.
Got Mr. S. Pandit, Learned Counsel to the petitioner. Okay, what is the H. Karolam, Learned Additional Senior, GA. Upon hearing the parties, this court at this point of time would require the case diary to produce the same, particularly with regard to particularly as far as the statement recorded, statement of the witnesses recorded under 161 CRPC and the statement of the accused recorded under section 164 CRPC. The prosecution is therefore directed to produce this copy of the said case diary on the next date fix. Case diary in connection with, what is the case number?
Criminal NDPS 2 of 2023.
Lordship, Special NDPS case number 2 of 2023, arising out of clear PS case number 10. Lordship is stated page number 1, Lordship.
Yeah. Arising out of clear PS case number 10 2 2023 under section 364A oblique 34 IPC read with section 21 under bracket B oblique 29 NDPS. Place this matter on.
The first is listed, the matter is listed in Clariat on first.
On first.
So let it come
on 6th.
6th, yes.
This is matter on 6th.
Monday it is not possible also.
I know, because first will be Friday. It will take time for them to.
Yes, yes. Okay. And this order I will furnish your worship.
Please do that.
Yes. On the same day.
Yes. One minute.
Item number 2.
Much obliged.
My lord, this matter relates to appointment of a headman and the remover. Now earlier, my lord, the appointment of the headman under the Millennium Sameship is governed by the Appointment and Succession of Chief and Headman Act 1956. Later on, my lord, the 6 villages in the Umsning town area, they form the constitutions and they make the constitutions, making the tenure of the headman for 5 years. Now, I'll just take Lordship attention to a few of the lectures. Lordship, you kindly come to page number 25. This matter relates to a remover of the headman.
25.
My lord, this is the constitution of Umsning town Darbar. So this governs the tenure of the headman. And page number, Lordship, kindly straight we come to page number 53. Tenure of the headman is mentioned there. 53.
Yes.
Point number 3, my lord. The term of headman and other executive members will be 5 years. If any reason there is a dissension among the villages against him, then a vote of no confidence will be carried out within ratio of such and such and such. So the term is for 5 years. Now, this was formulated in 2000 and accepted by 6 villages and accepted by the Millennium Sameship also. District Council also used to follow this. And District Council in 2007, they brought another act, Appointment and Succession of Chief Headman, Rangbashanong, Millennium Sameship 2007. There the period is not provided there. The period is not provided there. Now, therefore, they follow this. Now, consequent to this, the writ petitioner was appointed as a headman, page number 75. Well, this is a sanad issued on 19 January 2022. As empowered by Section such of the Act 2007 and administration of such rules, the chief and his third part of the Millennium Sameship through sanad had authorized you, Sri Sansar, to be the headman of Umsning Padarim for a period of 1 year. So they used in the sanad, they used to mention 1 year. but it is renewable for 5 years. That continued throughout many years. Now, this was continued, and thereafter, my lord, page number 78.
But if you see, if this is the case, why it was not pointed out to the mediumship?
Mediumship. My lord, this
since this is the act.
Under the act, the first one I read out is the constitution framed by the 6 villages.
Oh, constitution.
Really?
Does constitution have a a legal
my lord, that
legal status?
My lord, that is accepted by district council and even the respondent chief. I'll show those papers later, my lord. And for the time being, lordship, kindly come to page number 78. After I was appointed, the complaint 87, annexure 4, complaint dated 19 August was lodged. And these are the allegations that I was not taking the mandate of the collective members of Rongpashinong, others, misusing of fund. Those allegations are there. Nothing about the expiry of the 1 year. Because that is the practices for 5 years. Now, thereafter, my lord, the district council, the chief had issued the notice to the petitioner, page number 90, in view of this complaint, as to why action should not be taken against you, because few people has lodged a complaint. So this notice was given to me for my reply,
yes.
Page number 90, on 1st September 2023. And thereafter, my lord, I appear, and the preliminary hearing was conducted on, my lord, page number 92. It was conducted by the Mandri only, not the chief. Chief was absent on that day, but it was conducted on 8/9/2023. Complainant and the petitioner was also appear, and they have recorded a few statements. And my lord, the next page number 95, the same minutes, my lord, adopted by the Mandris. The last second para may I read out, my lord.
What is the type copy of this?
This is a type copy. Original is page 94 onwards. Original.
And that's what you are referring to, page 95?
I'm referring to 93.
Or 93.
Page 93. In the last second paragraph, may I read, my lord?
Yes.
With regards to Sanat, Rongpashinong has shown that Sanat has expired. The Mantri Sansat has shown that the Darbar Hima also will take a final decision regarding the complaint. Has requested the village headman that he should temporarily be stopped from with regard to the land documents, and if there is any urgency, he must consult with the village secretary. So his activities was restrained by the Mantris, that he should not take important decisions regarding the matter as a headman. Then thereafter, my lord, the application for renewal was recommended by the town committee, page number 99. Page number 9. So this is the practice going on there for quite more than 20 years now. And this was the recommendation. Now, subject application for renewal of Sanat of Hetman under the Umsning Darbar, Town Darbar. This was read to Right Mauro Opo for recommending. Writ petitioner name is number 3. So and their appointment is same date, 19 January 2022. All of them were appointed after facing elections. 5 of them were recommended. Well, and thereafter, my lord, what happened? The impugned letter order was issued, page number 102, 112. Well, on 19th September. Now it reads, my lord, the chief and his Darbar of medium sameship hereby make a public announcement in Umsning Padarim village, right such medium sameship, that Sri such has been removed from the post of headman of Umsning of such village after the expiry of his sanat dated such 19 January 2022. At the same time, appointed Mr. Vicky Millingap, village secretary, as the acting headman of Umting such. So Mr. Vicky was one of the main complainant, so he was appointed acting chief, and I was removed, saying that 1 year is expired. No one complained about with regard to 1 year. So my complaint, the merits of the complaint still survive, but chief ignored it, and he said that since your sanat is expired, I hereby remove you. So I agree with that. And thereafter, what happened? I filed, my lord, thereafter, page number 104. After this, the CM right Mabo has given recommendation 104 date 22nd September, application for renewal of sanats. Now 4 persons he has recommended. Now with regards to Sri Sajaj writ petitioner headman of Patarim village, White Order such 1909 has temporarily removed him from the post of headman. Therefore, with regard to this matter, the said letter is hereby forwarded to your kind office to do the needful. So in my case, since the chief has removed me, no recommendation, but the rest 4 of them recommended as usual. And thereafter, I agree with, I filed the political appeal, page number 106. And my lord, the chief also filed his show cause reply. My lord. And the chief show cause reply 11.1 may take 115. And 11.1 may take 117 para 8. Para 8, 117. Para 8, it says, with regard to the statement made in para 8 and 9 of the appeal, it is stated below. The appellant admitted before the third part that the sanat expired, and on perusal of the sanat of the headman of such and such expired on such, and after the lapse of 7 months, he did not renew the sanat. Yet this third part never interfere such, for the reason that Sri such failed to renew the sanat of headman. Therefore, he has no more power authority as a headman as per the such. So he removed me first, despite of recommendation by the third part, by the 6 villages. So he ignored that one. So that was his reply. Now, District Council has passed a final order. Page number 122. 122. The last one may I read out. I have heard both parties now Khasi Hills Autonomous District appointment and succession of chiefs, deputy CM, electors and Rangpa Shanong, Milim Semshik Act 2007 does not fix the period of the term of office of the Rangpa Shanong. Also, the sanat issued to the petitioner is only for 1 year. It does not state that the sanat is to be renewed on its expiry. The appointment order issued by CM White such 2023 is hereby set aside. However, the CM, in consultation with the CM of Right Murpo, is directed to appoint any monetary person to temporarily look after the said village till full-fledged Rangpa Shanong is elected. Further, the CM is directed to conduct a fresh election within such. So he set aside the CMship order. Now he fixed a fresh date for election. Now, pursuant to this, my lord, this is because of the expiry of my 1 year. Complaint is still surviving, still there, my lord. No one deal with. Now, surprisingly, page number 126 onward, my lord. The chief himself, respondent chief who removed me, has issued a renewal order, 25th September 2023, with regard to Mr. Sansach Molo. This is for 1 village, Rigamenti. He was renewed for another 1 year. For another person also, my lord, page number 129. Another person, my lord, Mr. Rocky.
Yes.
He is also recommended and renewed for 1 year by the chief himself. And another, my lord, page number 132. Another headman. He was also renewed and informed to the district council also by the chief himself. We were elected on the same day of election. And now, pursuant to this, my lord, the last order, impunge order, page number 134. the chief has issued this election date. My lord, we agree with this, my lord. May I just read a short order? I read out, my lord. With reference to the order in political appeal number such. Now, we received the direction from the EC, KHDC Shillong, to seize and to remove the order dated such and has appointed administration of village work at such to Sri such and to remove Mr. Vicky Millingap from the job of acting Rangpashanong of such. The office of the same Himamiliam had fixed a date on 30/11, that is tomorrow, for holding the election of the headman of Umsning Padarim. The timing for election is from such and such. Now here is the case, my lord. My complaint is another. Nobody dealt with that issue. Nobody has grievance with my expiry. And other 5, as usual, their appointment was renewed. In my case, it was removed. So this I have a limited grievance. So for today, my lordship, we can issue notice. And I prayed for staying this, the last impugned order. Otherwise, my lord, tomorrow they will conduct the election. My entire petition will become infructuous. Let them file a affidavit, my lord.
May it please, Your Lordship. Your Lordship, I'm for Mr. Vijay Kanta for KHDC. Your Lordship, we haven't received the copy yet, Your Lordship, so we didn't know what the matter was about, Your Lordship. So, Your Lordship, this matter can come up tomorrow.
We have served to, my lord, we have served to copy. This is one of the grievance faced by many lawyers, where I think the executive committee of the even bar may consider request to the Honorable Court. Now, district council matter, they have a council here, but they do not accept the notices. They ask us to go and serve to the department itself.
It has to come
So we go to department,
Yes.
we serve the copy. Without that, registry is not allowed the instructing council to file the petition. We serve the copy to them yesterday filing. Now we move it, my lord, and the situation arises that stay order cannot be passed. My lord, let them appear, my lord. We will serve the extra copy also. But tomorrow, if election is held, in time matter become infructuous. So, lordship, can issue notice? I will give a copy to my friend also, learned friend also. But it appears quite arbitrary, selectively dealing with the matter.
But even so, Mr. Sangreso,
My lord.
you know very well, see, settled principle.
Yes.
High Court will not interfere with election matters. Should not, in fact, except if it is pointed out that it is, done very arbitrarily, or without any rhyme or reason. As far as your case is concerned, you have, pointed out the sequence of things of what has happened. Admittedly, there was some complaint against you.
Yes, complaint.
And the Constitution also provides that if there is a complaint,
yes,
that has to be looked into.
Yes.
So, on the basis of such complaint, it could, like you said, it has not proceeded.
Yes.
But in any case, subsequent orders have come.
Yes.
The Sanat was not renewed. Perhaps based on that premise that there's a complaint against you. As far as the others are concerned, there's no complaint against them.
No complaint.
So, it's a smooth passage for them. Then you have also pointed out that you have pursued the matter, filed a political appeal.
Yes.
Then order was passed.
Right.
So there is no irregularity in the process per se. In such, and even I don't think, of course, your petition will be looked into because we are only at the initial stage.
Initial stage, madam. Therefore, only limited prayer may come out after 1 week or so.
I think as far as interim order is concerned, I don't think it is court granted. If you succeed, you'll be reinstated.
Well, my lord, that would, in fact, my lord, would frustrate. Here is a case, my lord, unique case where, my lord, similarly situated persons are renewed. Complaint is different, my lord.
But
complaint is
the
different.
provision is very much there. You yourself have pointed out.
That is true. So
Where
that is
that,
on record.
Where is that Constitution?
The Constitution.
Page is, what's the page?
My lordship. Page number,
50,
lordship, can you see page number 53?
53, yes.
53 is a 5 years. Point number 3.
If for any reason.
Yes.
So
now it says, if any reason that there is a dissension among the village against him, then a vote of no confidence My lord, it should be there.
Yeah, it should be.
Well, it should.
True,
So it is not there also. No confidence will be carried out with a ratio of 2/3 majority of the attendance.
But
So
you
they
have,
are-
but you also said you've also said that there's a complaint against you. Where is that complaint?
the complaint, my lord. The complaint is, my lord. The
you-
complaint
yeah.
is page number 78. And no one has grievance with the expiry of the 1 year. Because they know very well that January is 1 year to 5 years.
Of course.
So what the complaints, the quality of the complaint, Lordship, can you see page number 78. Number 1 is his selfish action. Number 2, he is disrespectful interaction.
Of course.
These are all the allegations. All these points. And when they appear before the Mantris, there was a statement. Lordship, can you see page 92? 92. And relevant statements were recorded from all the parties. And page number 93, may I say, my lord, read out. Second one. The finance secretary has added that there is no selfishness of Rung Pasnong in works relating to land. With regards to the land documents also, Rung Pasnong is never selfish. With regards to the money, it goes to the finance secretary. The money from land documents has never included in the village fund. The village headman has shown that he does not know anything regarding the issuing of pada. All those are recorded, my lord. On that ground, my lord, it is still pending, though the quality of the allegation is such. They themselves admit that there is nothing, no illegality committed by me. But that is subject to pending. I will face it. Now, instead of dealing with the core complaints, they pick up the non-related issue of 1 year and remove me, and for 4 persons, reduced. Discrimination is there.
If that is the prerogative of the CM of Millennium, who has issued the sanad, then there's nothing that can be done.
My lord, here is a clear
because he has acted under some authority.
He has the authority.
So if that is the case,
that is true.
If that is the case,
but I don't dispute.
Since even initially also, when the sanad was issued to you, it was stipulated that it will be for a period of 1 year.
1 year. My lord.
So
if it is not renewable,
so it stands to reason that if at the end of 1 year, if it is not renewed, and it is
my lord,
terminated.
My lord, if he did not renew to others, and all of us are stands allowed to go for fresh election, there is no discriminations. There is no pick and choose. But here is the case, my lord. Out of 5, 1 is removed, 4 are renewed. So this the CM action is discriminatory and arbitrary. It's quite revealing in his own order. He is extended. My lord. There's only limited one, limited protection. Till the next general date, my lord, election may be restrained. And let them file an affidavit, my lord. And it may be disposed of at admission stage.
Exactly. Yes, at the admission stage.
Admission stage, my lord.
Lordship, we need to see instructions, Lordship, because we haven't even received the...
Seek instructions, no, they can, my lord. Otherwise, tomorrow the whole election will be announced, my lord, there will be a fresh course of action, then I need to file a fresh writ petition that will multiply the litigations, my lord. So for the time being, my lord, I'm ready to take steps with other parties, other respondents.
I think this, as I've observed, I think the CM is well within his right to direct for election. Apart from the other reasons why he has done it, whether it's justified or not, I think that you have to prove your case. And if it was done arbitrarily, yes, of course. But since it is the process of, and now at this stage, the election is going to be held tomorrow. Preparation is already over.
only yesterday, my lord, they issued a notice.
Only?
My lord, the 27th, day before yesterday, they issued an impunity order. And that is on the direction of the district council. And the act is very clear. District council has no power to fix the date for election. The act, may I just place for lordship satisfaction? Section 16, madam. Section 16, may I just read, madam?
Yes.
Term of office, removal, suspension of the Reng Bashanong. Reng Bashanong shall hold office as per the terms and conditions in the appointment order, Sanat, provided that he may be removed. 16, madam. Section 18, madam. Section 18.
That's what I was wondering.
Madam, Section 18, madam. I'm sorry. Section 18. Term of office, removal, and suspension of the Reng Bashanong. Reng Bashanong shall hold office as per the terms and conditions in the appointment order, Sanat, provided that he may be removed from office or suspended by the chief or acting chief and his executive third. If he refuses to carry out the orders, if he violates any of the provisions of the Act or rules, if he violates any of the laws, regulations, my lord, he has been convicted of any offence, he is found incapable of carrying out on his duties and functions, he is found to be mentally unfit, he is found to have been conducting himself as a manner derogatory to his office.
Go only to the relevant portion.
My lord, these are the ground, my lord. These are the ground. And now
he has lost the confidence of the majority of the members of the.
My lord, that would need to be ascertained by non-confidence motion.
Okay.
They have to call for that one. They are not doing that one also. So the grounds are not available there. If these grounds are available, he can remove me. He can suspend me. He has the power. I have no quarrel with that. He is the absolute authority. But immediately here, no ground is made out regarding to the expiry of 1 year. And the year is not mentioned in the Act. Therefore, they followed 5 years. And accordingly, he extended to 4 of them.
But where is the provision which says that once the Senate is given for a period of 1 year, following the term of the resolution of the Constitution, which says that the term is to be for a period of 5 years, it is mandatory on the same of William to renew it.
To renew it, therefore, the constitutions which we read out, my lord, that which provide for 5 years, page number 53.
Yes, it provides for 5 years.
That they always follow that one. Same of William, they always follow. If they don't follow this one,
that would be a precedent, but it is not in the statute book.
Therefore, my lord, therefore this statute.
So again, we come back to the issue of discretion.
That is true. My lord, therefore discretion has to be exercised equally. Well, that is my humble submissions. Absolute lordship is correct. Egg is silent about the tenure. Therefore, the 6 villages formulated these constitutions, and chief always acted upon this.
Yes.
And accordingly, he renewed.
You see, under normal circumstances, it would be renewed. But why is your Senate not renewed?
My lord,
because of what has transpired.
And if it is complaint, my lord, he has to pass a final order on that.
That is a different thing.
He did not pass a final order regarding my complaint.
It is not necessary for the CM to even take cognizance of the complaint. If, like, again, we come back to the issue of discretion, if it is within his discretionary powers not to review at the end of the 1 year's term, then so be it.
But discretion is with him, but it is not unregulated discretionary power is not with him, my lord. He has to exercise it judiciously. Now he has the power to decide my complaint against me. He is not taking that decisions. On that basis, if he take a final decision on merits and remove me, that is another case. Another case that you are corrupt, you are unable to function, you are incapable, everything. He can remove me anytime before expiry 1 year or so. But he's not doing that one. He ignore it. You just say that, oh, your sanity is expired. Whereas these 4 gentlemen, I renew it. But this is apparent, my lord, discriminations. Only because of limited prayer. Respondent may respond it, my lord. It calls for some lordship interim protection.
In the meantime, the acting Rambasnam is there.
My lord, even one person has been appointed by the chief to look after the village. I will not become as headman. My concern is let the election be not held tomorrow. Caretaker may look after the affairs of the village, no problem, and lordship may decide it. If I fail it, election will be held. If I don't fail, if I succeeded, then I'll come back as the headman only. Caretaker is arranged by the chief. Let them manage the affair of the district by the affair of the village. that order is, my lord. Page number 134, madam. Second paragraph, they have appointed, the translation is, my lord, is there. We received in direction from the executive committee of the council to seize and to remove the such and such. This is the appointment of the other person acting, and has appointed administration of the village work at Om Singh Paradim to Sri Menti Ki Lengsit. He is the administrator now of the village. Let him continue, no problem. Well,
So even this acting Ramashna was also
he was also removed. Yes. I was also removed. Now they have replaced another person. Let this gentleman continue to look after the village for the time being. Hello.
Where's the authority for appointment of an administrator?
Administrator, that my lord, the egg is silent, but he appointed. The egg is silent. So therefore, those absolute chaos and confusion is there. Hello. Let the petitioner, let Mr. Vicky, main complainant, may not run the village. It's okay for the time being. Another person, Mr. Lengsit, who may be impartial, hopefully, let him look after in the meantime. Election may be, my lord, may be restrained.
And what would be the process of election?
Election, my lord.
The electoral process would be?
Electoral process would be the act itself provided here, my lord.
They call for filing of nomination?
My lord, the same act, section, my lord, section 16, lordship can you see? Election and confirmation of the Rang Pashanong, it is. When a vacancy occurs in the office of a Rang Pashanong, the same or the acting same shall, on the advice of the executor power, direct the Khasi male elders of the village urban locality concerned to summon a meeting of the heads of the household elders of the village urban locality, or the male elders of the village urban locality, as the case may be, on such date and time as may be fixed for him for the election of the new Rang Pashanong. Such a meeting shall be presided over by the Pasan, the Mandri, the Lingdo, the CM right, or the Lingdo right duly authorized by the same or acting same and his executive darbar. The result of the election will be placed before the same or acting same and his executive darbar for confirmation, and upon which shall issue appointment letter or sanad to the person concerned under such terms and conditions as the executive darbar may prescribe. Such action shall be intimated to the executive committee accordingly. So this is the procedure.
So the process of election, as could be ascertained from here, is that all the residents of the village is called. So they gather together, yes, as is usually done. Whenever Rang Pashanong is is elected, or nominated, or so there is no no formal process of filing of nomination. Period for canvassing, all those things. There's no such thing.
In fact, the egg is silent with
it's
regard
only
to
gathering of maybe a public notice is issued. They are together on such a date, and the agenda would be for election, and it would be by either secret ballot or by voice vote, whatever. So that is not specified here.
Not particularly specified. Not particularly specified.
But there's nothing wrong with this. You see, what I'm concerned is only with the regard to the period. You said that the notice was issued only on 27 November, and the election is supposed to be held tomorrow.
Tomorrow, madam.
So we have about 27, 28, 29, 3 days.
3 days, madam. That is why 3 days. And if we go to the detail of the constitution framed by the 6 villages, there's a period for filing nomination paper also. Election committee is there.
Or is that so?
It is there, madam. It is, madam. Just a point out
But
that portion.
if that is in conflict with the act of the with the statute, then what?
My lord, since statute is not elaborate, therefore they prepare this the local constitutions and they follow that one.
That should have.
You will not supersede.
That should have come in the way of by way of rules.
It should be incorporated in fact in the rules, but not yet till date. Not yet till date. But the practice they always follow this. Ultimately, the election is for the village, not for the chief.
Practice is only done only for convenience sake.
Convenience. Well, therefore, my humble submission, since caretaker is appointed, well, let him look after. Election may be restrained, madam, for limited period.
Yes, Miss, what to do? Since an order has to be passed in any
Yes,
case,
Your Lordship.
whether you are there or you're not there, order
Yes,
has
Your
to be
Lordship.
passed. And if I allow you to appear tomorrow, by that time, though, as Mr.
Yes, Your
Professor has submitted, the whole petition becomes infructuous.
Yes, Your Lordship.
So you, since you accepted notice, it will be recorded. And there are other respondents also.
Other respondent, my lord, 3 to my lord 7 may lordship may allow me to take step. 1 and 2, my friend is appearing.
Heard Mr. Mitchell, some Rasul Leonard, senior counsel appearing for the petitioner. Who has submitted that the petitioner was elected headman of Umsning Patarim village and has functioned as such on the strength of a sanad dated 10 January
19 January, my lord.
19 January
2022.
2022. His appointment as headman was by virtue of him being elected on as such headman on 10 January 2022. It is also submitted that the constitution of, where's the constitution?
My lord, this is page number 25. And the relevant one is page number 53.
Constitution of the Umsning Town Dorbar, Raj Maubu Mlim Simship, Riboy District, provides, inter alia provides for a headman, for the term of a headman and other executive members to be 5 years in all. However, the power to issue sanad lies with the aim of Mlim, who has administrative controlling authority over the said village, and who would issue a sanad to confirm the authority of such elected headman to function as such. The term stipulated in the sanad is usually fixed for a period of 1 year, which, as has been the practice, would be renewed from year to year till the 5th year expire. It is also the Learned Counsel, submission of the Learned Senior Counsel that in the meantime there was a complaint made by some of the residents of the village against the petitioner herein. Complaint was made against him before
the chief, my lord.
Chief means the CM.
My lord, CM, my lord.
CM of Milim.
CM of Milim, page number 78.
Before the CM of Milim. A complaint dated in 19/8/2023. How was the complaint dealt with, Mr. Professor?
Complaint, my lord, page number 78 is the complaint.
Yes.
And thereafter notice was issued to us by the chief, page 90, for hearing.
And after this, after the notice was issued?
After notice was issued, my lord, then the hearing was conducted, page number 92, by the Mantris, page 92, on 8/9/2023.
So this, so the complaint was, dealt with this,
by the Mantri, yes.
By virtue of this decision.
Yes, by virtue of this is a preliminary hearing by the Mantri, and the Mantri decided that the third party and the chief will take a final decision. Page number 93, Lordship May see the last paragraph. It says that the third party Hima will take a final decision.
Where is that?
That is page number 93, the last paragraph. With regards to Sanat Rungpashanong has shown that Sanat has already expired. Mr. Sansan has shown that third party Hima will also take a final decisions on the complaint.
So they have not decided on the...
Not yet decided.
On the merits of the complaint.
Yes, not yet decided.
Pursuant to such complaint, the CM of Milim has issued a notice upon the petitioner hearing, and pursuant thereto, the Mantri, a meeting convened by the Mantri of the CM-ship,
yes, ma'am,
has passed a resolution with the remark that the Darbar Hima will take a final decision on this issue.
Yes.
In the said resolution, it is also noted that the sanad issued to the petitioner has since expired. What is the decision dated?
Which decision, madam? The
by the Mantri.
Remover of the writ petitioner, my lord. remover is page number 102.
No, just
My lord.
8/9/2023. No, this is the resolution passed by the meeting convened by the
Mantris.
Mantri.
Mantris.
So that is
My lord, thereafter page 99, there was a recommendation for renewal by Umsting Darbar. Page 99 for all 5 of them.
Okay. Next. In the meantime, by communication dated 14/9/2023, the village, the Umsning Town Darbar has made a recommendation for renewal of the sanad of the headman.
Five headmen.
Five headmen within its jurisdiction,
including the petitioner.
Including the petitioner. And
thereafter, page number 102, he removed the writ petitioner instead of renewal.
Stop into more. Next. However, by the order dated 19/9/2023, the aim of Imam Lim has removed the petitioner from the post of headman on the ground that his sanad has since expired with effect from 19th. Is it 19? Oh, it has since expired now.
On page 104, he has renewed to 4 people, 4 headmen.
However, the sanad of the 4 other headmen have been reduced.
My lord, this is the recommendation by the Right Maupo. Page 104 is a recommendation by the Right Maupo for renewal to the chief.
But that has been the other.
First recommendation was by the town darbar, and
Right
Maupo is the customary higher authority, so he also recommended 4 of them, excluding the petitioner, because the petitioner was already removed by chief.
It is also on record. It's also on record that the Right Maupo has recommended to the aim of William the renewal of the sanad of 4 headmen, excluding the petitioner.
And finally, my political appeal, he passed the order, page number 122.
The petitioner.
Deputy CM has passed his order.
Petitioner being aggrieved by the order dated 19/9/2023 has filed a political appeal with the CM of Lim as the respondent. Political appeal before the Executive Committee,
yes.
Khasi Hills Autonomous District Council, with the CM of Lim as the respondent. What is the decision here?
My lord, page number 122, dated 17/11/2023. He passed his order, the last paragraph, my lord.
The said political appeal was decided by the Executive Committee by order dated 17/11/2023. Which in effect has confirmed that the sanad issued to the petitioner is only for 1 year, and there is no indication to say that the same is to be renewed on its expiry. Accordingly, the appointment of the petitioner was set aside, and the aim, in consultation with this aim of Right Maubo, was directed to appoint any Mantri oblique Basan to temporarily look after the village till a full-fledged Rambachnong is elected. It is also further directed that fresh election be conducted on 30/11/2023. It is primarily this order dated 17/11/2023 that has caused grievance to the petitioner, for which this instant petition is accordingly filed.
On page number 126, if Roshi permits me, these are the renewal order to other three gentlemen, other three persons.
But that has already been said. That has already been indicated that they have been renewed. So not necessary to go through. The senior counsel has submitted that the complaint against the petitioner has not yet been addressed, and since the standard of the other four headmen have been renewed, an order was passed accordingly, the non-renewal of the sanad as against the petitioner is discriminatory in nature, and because of the arbitrary act of the concerned authority, prayer is made before this court. Or what is your prayer?
The last order is page 134.
No, you have
impugned
to-
order.
134,
impugned order fixing the election date by the chief.
No, that is.
Lordship is yet to record that one.
Or this is the order. Shwai katu ni, shwai katu ka imo tu ka paragraph. The Learned Council for the Learned Senior Council has also pointed out that White Order dated 27/11/2023, the CM of William has directed that the election of the headman of Umsting Patarin be held on 30/11/2023, and this order is okay. This was the extract of the order dated 17/11. The order dated 17/11/2023, whereby a Mintri, whereby Shri Mintri K. Lingdo was appointed as administrator, and Shri Vicky Malingap, who was the acting Ramashno, was removed, was also pointed out in the said order dated 27/11/2023. So Act 1 being agreed by the order dated 27. At this juncture, the learned senior counsel has submitted that notice may be allowed to be issued upon the respondent number 3, 4,
Till
5,
7, my lord.
6 and 7, while the respondent number 1 and 2 has accepted notice through Mr. It is also something that in the interim, while allowing the respondents to make their appearance and to file their counter affidavit, due to the urgency of the matter and the fact that if the impugn order dated 27/11/2023 is allowed to continue, this petition would become infructuous, and for such reason this court is persuaded to pass an interim order causing a stay of the election process. Mr. has submitted that firstly, copy of the petition has not been supplied to her, and secondly, since the learned senior counsel who's representing the respondent 1 2 is not present today, hearing of this matter may be taken up on some other date, including the hearing on a prayer for interim relief. This court, upon consideration of the prayer made, would note that there are conflicting interests to be addressed as far as the averments and the prayer made in this petition is concerned. The main cause being the status of the petitioner as the headman of headman of Umsning Patarim.
Patarim village, Umsning.
Patarim village, Umsning. Though it is too early in the day to come to any conclusion as to whether either side could make out a case in their favor. However, at this point of time, seems I'm very conscious of the fact that your sanad has already expired. See, that is.
That is my lord. No one complained. Only prayer. If Lordship give us some protection,
What
let them come
protection
up with a
do you-
modification for alteration of the interim order.
Court cannot compel the authorities to renew your sanad.
I'm not seeking for renewal.
No, because in effect, you see, if you are to continue, it has to be renewed.
My lord, that is that issue.
So where is the issue?
My lord,
Only if you are being prevented from, contesting, then.
my lord, once election is held, there is no question about my renewal. Then my renewal is gone. That is why, my lord, if Lordship give limited protection, the next time they may come up with the application for modifications. If I fail to make out, my Lordship may vacate the interim order also.
Going to go. The last line. Whether either of the parties can make out a case. Either of the parties can make out a case in their favor. Since the petitioner prima facie has made out a case of apparent discrimination as far as the renewal of the sanad vis-a-vis the other headman is concerned, this court would be inclined to, this court is constrained to order for a stay of the election proceeding, which is to be held on 30/11/2023 for the time being. The process of election will be subject to further orders to be passed by this court in this respect. It is, however, open to the parties to approach this court with any application or prayer for modification, alteration, or modification or alteration of the said interim order pass. The interim order will be sustained till the next date fix. Have I directed for issue of notice?
My lord, I'll take a step.
I'll pass over. Notice issue returnable within 2 weeks more. Is this matter on? When do we list it?
My lord, this is December. December is this side now.
So we'll list it on 7 then. This is matter on 7.
Yes.
That will give them time to
yes.
file any application.
Yes. Madam, I'll take step also.
Right,
I
Your
do.
Lordship.
The main list is to be. So what do we do?
Lordship, pray for some indulgence, my lord. Item 1 in Lordship's main daily list, it's an admission hearing stage. I'm the petitioner. It's a revision petition against order passed by lower court. Some time will be taken in that matter. If it can be taken any other date, my lord, maybe next week, if that is convenient.
Lordship, I may point out here, Lordship, as an appellate court, has passed a decree, a compromise decree where the respondent hearing is a party. And that has not been enclosed along with the...
This court?
Yes, Lordship. That has not been enclosed, those documents.
That is between respondent and some other person. Some
Still,
other matter,
Lordship,
not
those are
not our
pleading,
matter.
are part of pleadings.
Anyway, that will be considered later. If certain documents, certain letters or whatever is missing, that can be incorporated, orders, whatever. We are here only at the stage of admission of the petition.
Yes. In fact, it's a very small matter. It was for disposal at the admission hearing stage itself.
Fine, we'll take it up next week then.
Lordship, but I will point out that only, Lordship.
Okay.
Yes. Because
this is item 1, my lord.
And you are put to notice as far as that is concerned.
Well, I'm aware of this. I'm aware of this. I'm conscious of what my friend is trying to say, but I submit that that will not stop Lordship.
You can address that issue accordingly.
Very well, my lord.
On pre-made by the parties, let's this matter after 1 week.
Obliged.
Lordship, item number 20. In the morning, I was making mention that the petitioners could not be contacted. Actually, in this case, I was supposed to get the original record of the inquiry report, but and I've asked for, and what they have sent it, the red petition, copy of the red petition. So I need a further time to call for the record again, Your Lordship.
Who is for the petitioner?
The petitioner, I could not contact him, Your Lordship, today.
On pre-made by the respondent, this is matter after 2 weeks.
I'd like to mention item 15. Mr. Hazarika is here.
After a week, my lord. Next week. I need it.
Nokma issue.
What is any urgency here?
No, Lordship.
That is a Nokma dispute. Next week, my
Yeah,
lord.
go next year. What is there?
Urgency is there, my lord.
Urgency is there. Next week means next year.
No, my lord. Next week, because my
Right.
client
After
is bedridden, so before that I want to
your client
substituted.
1 week, my lord.
Right, we'll see. On pre-made by the parties, this is matter up to 1 week.
Yes, much.
Well, at item 2, the the petitioner is supposed to.
Lordship, with regards to this matter, we have already consulted the registry, Lordship, and it seems we have to pay around ad valorem court fees, Lordship.
Yes, madam.
So this issue, Lordship, and we have consulted the registry, and it seems we have to pay around 11,000 rupees, Lordship. And this,
Ad valorem court fee is always paid. I don't know why. I thought some rules are there.
yes, Lordship. So after consultation, Lordship, we found
So
out
we'll
that
do
we
one
have to
thing.
pay, Lordship. So
I'll not pass any order here. You pay the
We'll
and
pay
then
the
the matter comes up.
Well, this is
Lordship,
already an order for
Lordship, we
paper book also.
yeah, we applied for paperwork, Lordship, and we are yet
First
to
we'll
receive
deal
the
with
copies.
Ad valorem court fee first.
ad valorem court fee issue
That's the first hurdle.
as paid for by the
After 2 weeks, madam.
2 weeks,
They
Lordship.
will pay in the meantime.
as paid for by the parties. This is matter to 2 weeks.
Obliged.
Highly obliged, Lordship.
Your Lordship, item number 17, Your Lordship. Apparently, it will come after 2 weeks. Your Lordship.
2 weeks.
Yes.
On premier petitioner, this is matter to 2 weeks.
Item 16, my lord. Here also, my lord. This matter is taken up after 2 weeks.
No objection, Your Lordship.
You're for respondent?
My petitioner, Your Lordship.
On premier by the respondent, state respondent, not objected to by petitioner. This is matter after 2 weeks.
Wait, please, Lordship. If I may be allowed to mention item number 3, Your Lordship.
Excuse me.
Your Lordship, here, Your Lordship, we have already taken steps and the respondent is being presented today, Your Lordship.
Lordship, I'm appearing for the respondent, Lordship.
You're for the respondent?
Yes, Lordship. We will be filing the wakalat within a week, Lordship.
You have not filed a power?
No, Lordship.
Mr. has entered appearance on behalf of the respondent and has submitted that the power could not be filed today and has sought for time to file the same. On premium, the same is allowed. List is matter after 1 week. 1 week.